May I please lordship, back to mention, for listing of the MSc appeal, I filed on 20th of March. There is orders column because there is a delay of on 2nd of April. Next Thursday,
Fresh appeal,
my lord,
fresh appeal.
fresh appeal.
Okay. Okay.
There is only for delays there, for OC, you notice, my
Lordship, I beg to mention for listing two MFAs. We have mentioned this earlier also, Your Lordship, however, the mention has not come up. Due to the urgency, can it be listed on 30th of March, this Monday, Your Lordship? We already mentioned it earlier at
20 April.
28th. Well, Lordship, it was supposed to be listed on 20th of March.
After Bihu. 20 April.
Much obvious.
May I please, Your Lordship? Lordship, I filed a CRPIO on 10th of March, my lord. That has not been listed yet, my lord. It is for motion, my lord. That may be come up for on 31st March, my lord. Tuesday, my lord.
Okay.
For motion, my lord.
Okay.
Lordship, give me.
May please lordship, this matter, MSc appeal matter was last listed on 16/9/23. There is an order for producing the original pension paper. Pension paper was with me, collected the pension papers original, but till date we could not produce the same. There is an order, lordship, can you see? Lordship,
20,
on 31st,
20 April.
last 3 years
20 April.
with me, original pension paper.
We are full with cases. 20 April.
Obliged, lordship.
May it please, Lordship. Lordship, from the item number 30 to 37, we have filed an objection in 4 cases, and in other cases, we need 2 weeks' time, Lordship. It's a weak matter, all this.
Stop for it. Also, stop to condition. So,
Item number 32.
37, my lord.
You are praying for adjournment today.
Yes, Lordship.
Other side,
The applicant.
heard Mr. What is your name?
A Deka.
Heard Mr. A. Deka, learned counsel for the respondent
The 3.
who prays for adjournment for enabling the respondent, private respondent to file objection against the prayer for condonation of delay. Delay. Also heard Mr. A. Das, learned counsel for the applicant who does not oppose the prayer. The prayer is allowed. Let this matter be listed.
After 2 weeks, Lordship.
29th April.
Actually, interim orders to continue.
The interim order shall continue.
Actually, there is another matter left, Your Lordship, that will be tagged along with IA number 4219. IA civil number 4219 of 2025.
When it is listed.
It is listed on Monday.
Monday you make mention.
I'll do that now.
Lordship, the objection has already been filed on 33, 35, and 36. And also in 31.
I'm appearing in 31, Lordship, for respondent number 1. Objection has been filed. All the cases similar, the condonation of delay by appellate filed by the NLU. So all the cases may come together.
33,
33,
31 also, Lordship. 31.
31,
31, 33, 35, and 36.
35 and 36 separate order. Only adjournment prayer is allowed. 37, prayer for adjournment is allowed. Nothing else need to be mentioned there.
Interim orders to continue.
Interim order shall continue.
Much obliged.
Lordship.
May I please, Your Lordship? Lordship, listing of MSc appeal to MSc appeal in the orders column after Bihu.
20 April.
Wait, please, Your Lordship. Your Lordship, I beg to mention listing of 2 MFA. Your Lordship, can it be listed on 24th of April?
24th April.
Obliged.
May I please, Your Lordship? Lordship, I beg to mention for listing of an RSC matter for hearing, Lordship.
When it was last listed.
It was last listed on 22/7/2025, Lordship, 2014 matter.
18 June.
Obliged, Lordship. May it please, Your Lordship? I beg to mention case number 4081/2025
For listing.
for listing, Your Lordship.
Yes.
This
yes.
is in testamentary appeal number 14552 of 2025.
Hearing column. Orders column.
Yes, Your Lordship.
20 April.
Your Lordship, can you fix in the next week?
20 April orders column.
Much obliged.
Please, Your Lordship, I beg to mention one RSA for listing in order column.
20 April.
My lord, a matrimonial dispute has been settled in mediation center, my lord. My lord, it may be,
When do you want?
my lord, on my lord, on my lord, 8th, my lord.
8th of April.
8th,
Okay,
8th of April.
okay.
May I please, Your Lordship, appear for listing and sharing orders and correction of your Lordship order. Monday or Tuesday?
Tuesday.
Tuesday.
Correction,
Correction your Lordship's order. Yes.
typographical error.
Small mistake is there, yes. Course number is, yes. Instead of everywhere, it is written as Tinsukia, yes.
Okay, Monday.
Obliged.
Please, Your Lordship, I beg to mention item 52, Your Lordship. We have applied for a certified copy of cross-examination part. Lordship, we have not received it till yet.
So what is your prayer?
Lordship may kindly fix on another date because,
You have informed the other side.
yes, Lordship, we will inform.
They have informed.
We have tried contacting them, but we have not.
Then you have to wait. Wait for
obliged.
your turn, or you can mention at 2 PM after informing the other side.
Obliged.
My lord, these two appeals we intend to withdraw, my lord.
When do you want?
My lord, if it can be on Monday, my lord.
Okay.
Obliged.
Daily list, motion PA, item 1.
My please, Your Lordship. The regular well-fixed Lordship. The certificates are filed, the case is also registered, Lordship. The case is pending at the evidence stage, Lordship.
What is the method?
Lordship.
What is the allegation?
Delegation, what is the?
Lordship, surgeries has been paid under section 103. At the case is already released on bail by the Honorable Court, Lordship. I have annexed that order, Lordship.
Why your prayer was rejected?
During the pendency, Lordship, it was rejected by the trial court, Lordship.
Where is the rejection order?
Lordship will find it at page 57.
Eyewitness, witness, my lord, above mentioned accused assaulting the disease, my lord.
Lordship got it, Lordship.
Second paragraph.
In this case, I was already filed charge sheet against the above named accused and others for offense under so and so after having found sufficient material against them. Result of the search sheet and other matters revealed that there are eyewitnesses who have witnessed the aforementioned accused person assaulting the deceased, Lordship. In view of the above, the bail period is rejected, Lordship. There are local people, Lordship. Second one is.
Who
the
has
Lordship-
been granted bail?
Lordship.
Who has been granted bail?
Lordship, co-accused, Lordship.
How many?
Lordship, Junmoti Pego, Lordship, Eliza Pego, Ranjita Pego.
Do you stand on the same footing?
Yes, yes, Lordship.
Yes, Mr.
My
Parasha.
lord, these are all ladies. my lord.
Searched. They were also searched, Lord.
Succeeded, but.
Okay, we'll
as per
call for the scan copy of the
PCM, my lord.
record.
Lordship.
And
It is pending at the stage of evidence, Lordship. And they are local people, Lordship.
let us see. Let us
No,
examine
no,
what
it's not,
materials are there.
No witness.
Heard Mr. B.K. Gogoi, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. Perusal of the scanned copy of the trial court records would be necessary for consideration of the instant bail application. Hence, let the scanned copy of the trial court records as well as scanned copy of the connected case diary be called for from the trial court. List this matter 29th of
Can
April,
it be, Lordship, before Bihu, Lordship?
not before Bihu. After Bihu. 24th April.
Last day, eight lordship.
Eight-
8th of April, lordship. I'll travel last lordship.
Okay, 8th of April.
Authorized lordship.
Preliminary PA item 14.
Fourteen and 15 are same, my lord, and in the 15 there is scan copy is there, my lord. On the same PS. Same PS case.
May I please, your lordship? This is the second bail application, my lord. My lord, apart from the grounds taken in the bail petition, my lord, another additional grounds has been taken, my lord, by additional affidavit, my lord. Kindly see at page, my lord, 74 is the running page, my lord, from the additional affidavit. And relevant portion, my lord, 77, my lord. My lord, in this case, my lord, the accused persons were arrested, my lord, wherein they have been served notice under section 47, my lord. Though notice has been served, my lord, but it was not, the grounds of arrest were not mentioned clearly, my lord. In the ground column, my lord, kindly see page 77. Ground of arrest. Total 2,102 numbers of light blue capsules and 133 numbers of navy blue capsules were recovered and seized from his house premises. This is the ground of arrest, my lord. This is the only format of seizure list, my lord. The case and the above, my lord, only case numbers and sections are referred, my lord. The proper grounds of arrest has not been mentioned. So the arrest is totally illegal, my lord. And the mandatory provision of section 47 and article 22 subclause 1 has not been complied with, my lord. And my lord, in this regard, my lord, this honorable court has passed several orders, my lord. In this regard, I am submitting, my lord, two judgments passed by this honorable court. One is from this honorable court.
When is the date of your arrest?
My lord, dear, date of arrest is 1 year, 1 year is completed, my lord.
4/4/2020.
2020,
25.
six days left to complete 1 year, my lord. And these two judgments, my lord, the Supreme Court judgment of Bihan Kumar, my lord, Probi Prokashta, my lord, and Pankaj Bansal is clearly discussed, my lord. And the matter is same, my lord. In this case, my lord, though the notice was served, but the grounds of arrest were not mentioned.
No, you have been intimated that capsules were
Yes.
seized from your possession.
My lord, this is the format of seizure list, my lord. This is not the ground, my lord. The ground should be, my lord, the ground should be clear, my lord. The ground should be clear, my lord. In this
Before-
judgment, my lord, it is clearly says. my lord.
And what else?
My case is with this, same as this case.
Before FSL, whether it can be said that heroin, methamphetamine, it cannot be said, my lord.
Oh, why?
Then you cannot arrest him.
No, my lord, suspected.
No, on what is the basis of suspicion? If only on the suspicion you start arresting people, you can arrest anybody. Preliminary,
My lord,
the
whether drug detention kit.
drug detection kit has to be used
that-
and a primary satisfaction has to be arrived.
my lord, that my lord, order has to be seen, my lord.
In the grounds of arrest, it should have been mentioned that it is suspected to be heroin on the basis or so and so on the basis of this examination.
My lord,
Mere finding of capsule,
now, my lord, we have to see the FSL, my lord. FSL is already succeeded case. FSL is there, my lord. FSL is there, my lord.
no, their plea is that they were not intimated about the grounds of arrest.
Capsules were found and subsequently
Mere finding of capsule,
subsequent, it is proved that, my lord, these capsules are, my lord, contraband drug.
Mr. Parashar, before arresting a person,
My lord,
you must come to a finding that capsules might be contraband. And on the basis of some preliminary examination, that satisfaction has to be arrived at.
this is, my lord, too technical, my lord. That is there, my lord.
Now, when you are arresting somebody, Then you have to follow law. What is your submission?
Well, my submission is that, suspecting to be a drugs, it is, they were arrested. Subsequently, in the FSL, it is proved that these are drugs.
Where is the original?
And that first production order, just I have to see that order, order I have not.
No, what is your submission? Response to his submission. This is your only submission.
My lord, this is the arrest is, my lord, illegal and not
Well,
properly.
Bihan Kuman and other judgments, not at all any grounds of arrest were given. Here, arrest of, grounds of arrest was given. These tablets were found on your position, suspected the drugs. That suspected drugs, subsequently it is proved. When FSL is proved, accordingly such it was given, Now,
And in 15? Who is appearing for 15?
15, he,
And same case, my lord. Same.
Same
account,
ground.
Same FIR.
Malad mein Perus PW4, Caesar witness PW4, he is the independent witness. He is from first search in the house, subsequently in the boundary wall near these tablets were found. And PW2 implicated the petitioner in San Muhammad Muhammad Chan He sold this capsules to Mojibur Ali. And now up to PW7 examined out of 10 witness. 10, na?
Total 12.
So to 12 witness, 7 examined
Where is the last rejection order?
Last rejection
My
order.
lord, the last rejection order is at page, my lord, 68.
68.
It was on 11/12/2025.
In the order it is mentioned, page 70, containing 1388.67 grams of suspected narcotic drugs.
Okay. Heard Mr. A.K. Azad, learned counsel for the petitioners. Also heard Mr. K. Parashar, learned additional public prosecutor. By this common, next 16th. By this common order, this court proposes to dispose of 2 bail applications, namely bail application number 387/2026, filed by the petitioners, namely, how many petitioners?
3.
1, 2, and 3, as well as bail application number.
No, sorry. In item 14, there is 2. In item 15, 1. Item 14.
Two petitioners, namely 1 and 2, as well as bail application number 391, filed by the petitioner, namely Muhammad Chan. Date of arrest is same.
No, my lord.
Muhammad Khan-
Item number 14, my lord, they arrested on 4/4/2025.
Item number 15 is 28.5.
The petitioner, namely 1 and 2, were arrested on 4/4/2025,
Right.
whereas the petitioner in bail application number 391/26, namely Muhammad Chan, was arrested on
28/5/2020.
28/5/2025. This is for the second time above named petitioners have approached this court. Their earlier bail applications were rejected by this court after perusing the materials against them. The gist of accusation in this case is that Court Para 3 from page 70, page 60, 69 of item number 13. What other grounds are you praying?
My lord, apart from other grounds, this new ground has been taken that
Other grounds you have taken earlier also.
earlier also, my lord.
This time the aforesaid above named petitioners have approached this court with an additional ground by way of filing an additional affidavit that the notice under section 47 of the BNSS served on them at the time of their arrest was not in accordance with the statutory mandate of section 47, as it does not disclose grounds of arrest. Stop. Learned counsel for the petitioner submits that the notices which were served on the petitioner under section 47 of the BNSS mention following in the column grounds of arrest within inverted comma, total 2102 numbers of light blue capsules and 133 numbers of navy blue capsules were recovered and seized from his house premises. He submits that the aforesaid grounds does not disclose any implicating material against the petitioners. He submits that the grounds stated in the section 47 of the stated in the notice under section 47 of BNSS, which was served on the above named petitioners, were not in pursuant to the observations made by the apex court in the case of Prabir Purkayastha versus state of within bracket NCT of Delhi, reported in 2024 8 SCC 254, as well as in the case of Vihan Kumar versus State of Haryana and other reported in 2025. SCC online SC 269. He submits that as the grounds of arrest were not communicated in pursuant to the mandate, in pursuant to the observations of the apex court in the aforesaid cases, there is violation of Article 22 of the Constitution of 22 within bracket 1 of the Constitution of India, as well as Article 21 of the Constitution of India, and therefore they are entitled to get bail in this case. On the other hand, learned additional public prosecutor, Mr. K. Parashar, has submitted that this is not a case where no grounds of arrest has been stated in the notice under section 47 of BNSS. He submits that the notice which was served on the petitioners under section 47 clearly states the fact of recovery of capsules from the house premises of the accused persons, which were later on found to be prohibited drugs after forensic laboratory report. He therefore submits that the mandate of section 47 has been complied with in this case. He further submits that
My lord, only one line, my lord, that seizure list also, search and seizure also stated that suspected drugs.
he further submits that the seizure list which was prepared at the time of recovery of the aforesaid contraband, what drugs was there? Tramadol,
Not tramadol,
FSL,
FSL, my lord. Well, I have not. FSL, my lord, I have not seen FSL.
he further submits that Tramadol. He further submits that the forensic laboratory examination, forensic laboratory report of the recovered contraband found presence of prohibited drug that is tramadol in the recovered capsules. He further submits that on earlier occasion when the appellate petitioners approached this court had rejected their bail application after considering all the aspects, and at that time the plea of any violation of Article 40, any violation of Section 47 of the BNSS was not taken by the petitioners. He therefore submits that the bail application is liable to be dismissed. I have considered the submissions made by learned counsel for both sides. I'll pass orders in chambers after going through. Proceed.
FSL, tramadol, I have to take mark.
The trial court records are there.
My lord, yes.
Ekelebe chamber.
Obliged.
Item 54 from supplementary list.
May I please tell us? I would kindly have a look my additional affidavit.
Yes,
Additional affidavit, my lord. Page 73, my lord. Where are 2, 3 and 4, my lord. May I read?
what is the case?
Case, my lord, 2 persons were found in the vehicle. And the vehicle was containing of 8,700 something gram of yaba tablets. 2 person, my lord.
8,000?
It is, my lord, 8,576 gram
Of
yaba tablet, my lord.
Yaba tablet.
Yes, my lord. And
Containing what? Tramadol?
containing
Methamphetamine. Okay.
So, my lord, 2 persons were arrested, found in the vehicle, my. And as per the JDNT, whatever the records, my lord, it is said that we both were taken into custody more than 24 hours. We have produced before the magistrate after completion of 24 hours, which is violation of Article 22, Article 21, and Section 50 of CRPC. My lord, so on the same footing, my lord, that out of two, one of them granted bail on the same footing by the coordinate bench, which I have annexed, my lord. So my additional affidavit, kindly have a look, my lord, what I have annexed everything. Page, page 73, para 2, 3, and 4, my lord. And in that case also, my lord, the learned PP Mr. Parashar was there, my lord. Surprisingly.
Where is the earlier rejection order?
Earlier rejection order, my lord, page 49 of my petition.
This plea you have not
That-
taken.
No, not taken
lord.
at that time, my lord.
At that time, because what happened, my lord, at that time it was filed during the course of investigation.
Then why
And
are you?
subsequently, my lord, charge sheet was filed, man. After filing charge sheet, we have gone through the record. Because at that time, my lord, during the course of investigation,
No.
my-
Whether you are produced before within 24 hours or not, for that records are not necessary.
my-
You yourself know that from the date of arrest.
my lord, we know, but we are under the police custody, my lord. Something if we rise before the police, that cannot be looked into, my lord. Because at that time, because we are not reached to the lawyers, my lord. The situation is circumstances not tenable and that like, my lord. So, my lord, I have come across and I have gone through that one. And learned, coordinated by
What
the,
is your name
my name is Shamiuddin Beg
and
and Tanzil Abedin Talukdar. Two persons were arrested. Tanzil Abedin Talukdar are granted bail, my lord.
where is that bail order?
That bail order, my lord. Kindly see, my lord, page 87.
Okay. Which judgment you are relying?
My lord, I have annexed this one, my lord. Page 80, my lord. Directorate of Enforcement versus Subhash Sharma.
Which paragraph?
Page 80, paragraph, my lord, paragraph 6, and 7, 6 and 8, my lord.
There is 2:30 PM on 15.
130 search, my lord.
Okay. Now where are the facts? When you were arrested and when you were produced?
Arrested, my lord, kindly see, my lord, the page 76, annexure 1. The GD number 12, my lord.
Yes.
It is 16/3/2025 at 3:15 PM. I, along with Tanzil, my lord, were taken from the PS towards court for forwarding. It is 3:15 PM, my lord. At GD number 12 and GD number 22, it is 8:20 at night on 16/3/2025 that I have already been forwarded. Now, my lord, the seizure list says, my lord, page 20 of my petition, my lord. The seizure list says 15/3/2025 at 2:30 PM, seizure was completed.
But you were not arrested
My lord,
when you were arrested.
that Subhash Sharma judgment is saying that Director of Inquiry said that the time of detention should be calculated.
Yes,
I
when
was
you were,
taken arrest, my lord. I was shown arrest for the next day. I was taken into custody prior to 1:30 PM on 15/3/2025.
where is that material?
My lord, this is search was made, my lord.
No, search may be made, but you may not be arrested for
I was
conducting.
detained, my lord. I was detained. The period of detention should be counted, my lord. I'd like to submit.
Where is the material to show that you were detained by?
This is, my lord, these materials, it is search memo showing that the search was made 1:30 PM at,
Search can be made even without arresting you.
my lord, I was.
It
at the
is not
vehicle.
necessary to arrest you for,
My lord, before completion.
you have to show to the court that you were arrested before or you were detained before such.
I was shown arrest, my lord, on the next day, but I was taken into detention on the previous day, my lord.
On what basis you are saying?
Because seizure was completed at 2:30.
Seizure is a different thing. Seizure is a seizure of contraband and arrest is a arrest of person.
My
You-
lord, what I'm saying, what I like to say, my lord, the 2:30 PM, the seizure, my lord, we were found at the vehicle. Without taking into detention, the seizure cannot be made because we later we have not been detained. We detained at that moment, my lord, when the vehicle was intercepted. At that particular moment, we were detained, my lord. So, my lord, that detention period should be counted pursuant to the Director of Enforcement judgment, my lord. This is on that ground, my lord,
Where is that?
my lord. Page 82, my lord. Page 82, I would like to place this one, my lord. The finding of fact recorded in paragraph 10 is that undisputedly the physical custody of the respondent was taken over by the appellant from the Bureau of Immigration at 11 hours on 5th March 2020.
Yes, those facts are different.
That fact is clarified, that judgment clarifies that it is the detention period should be counted. In that specific case.
Yes,
also,
you show me when have you detained, whether for conducting search you were detained or not.
Because we were intercepted at the vehicle, my lord. We
Where
were
is
in the
the-
vehicle. It is in the FIR itself, my lord. It is in the FIR itself, that we were in the vehicle, my lord. So when the vehicle was intercepted, we were in the vehicle and in our presence, then keeping ourselves in detention and the search was made, my lord. It is in the FIR itself, my lord. Since in the morning, 15/3/2025 in the morning, that vehicle was intercepted, my lord. So, my lord, it is clarifying fact that, my lord, on the same footing, my lord, after going through this record, my lord, coordinate bench, my lord, pass the judgment.
Where is the seizure list?
Seizure list, my lord. Page 20, my lord. Date and time of seizure 15/3/2025 at 2:30 PM.
Where is the arrest memo?
Arrest memo, my lord, I have gone through. In the arrest memo, no signature is taken.
Where is the arrest memo?
Arrest memo, I have not annexed here. It is on record, my lord. It is on record. No, even this is also, my lord, stayed.
Record due.
This is also, my lord, bad in law, my lord. Because no signature was taken, no witness signature was taken, my lord.
What is the time shown of arrest?
I'm shown, my lord, on 16/3/2025 at
Eh.
10 AM. Although, my lord, In some record 10 AM, in some record no time was shown, my lord.
Where you were kept from 2:30 PM to 10 AM?
It is, my lord, in the police station.
Have you made that statement in?
Overall statement I have given that 24 hours were taken into custody.
No. Have you made that statement in your petition that during this period you were detained in the police station?
My lord,
Where?
page 73, that the deponent begs to the two persons, one is petitioner so-and-so, that the deponent begs to state that the vehicle was intercepted in the morning on 15/3/2025 and seizure was completed at 2:30 on 15/3/2025. The search was completed at 1:30 PM on 15/3/2025, which substantiated that the petitioner along with the co-accused was taken into custody on 1:30 PM on 15/3/25.
No, after seizure process, your submission is that you were detained in the police station without producing you before the magistrate. That is your submission. Where is that?
It is FIR itself, my lord, because in the FIR saying that
No, where is that pleading?
specific that time that period was we were taken into police custody. Specific that I have not mentioned, but overall that
No, mention it.
my lord, this is five. I'm overall saying that
Arrest memo bola 16/3/25 at 10 AM.
10 AM. And my lord, at 10 AM, it is in arrest memo, my lord. And in arrest memo, my lord, no signature is there, my.
No,
Even no
no,
signature.
Mr. Chaudhary. Your contention is on 15/3/2025 at 2:30 PM search was made and you were shown arrested at 10 AM on the next day.
Next day.
Where were you kept during this?
We are kept in the police station.
Where is that
I
state?
specifically, that line is not mentioned.
Mention
But
that line.
Police,
Otherwise, how this court will know?
my lord, for within, because it is my lord,
Where were you during that period?
in the police station, my lord.
Where is that statement? From what what material court will come?
But FIR in FIR, police is saying that. Police is saying that we have taken into detention, we have forwarded on the next day. It is in the FIR, my lord.
Show me.
Page 15, my lord. As per instruction, I along with my team departed
Now
from
directly come to that place where
page 15 in middle paragraph, my lord. My lord, kindly have a look. It is page 16, second paragraph. After intercepting the vehicle, page 16, second paragraph, my lord.
yes.
After intercepting the vehicle, I disclosed my identity to the occupants. As my team cordoned off the vehicle and began questioning the driver and co-driver. Owing to the Holy Festival, no individuals were present at the scene to serve as witnesses. Consequently, we contracted two individuals, namely so-and-so, son of so-and-so, District Assam, apprised them for situation and sought their assistance to act as witnesses. They willingly agreed to assist, and subsequently on their arrival at the spot, we requested them to conduct our body search so-and-so. During spot interrogation, the detained driver, that is already detained, my lord. Detained driver identified himself as Shamimuddin Beg, son of so-and-so, and the co-driver of the vehicle identified himself as Tanzil Abedin Talukdar, so-and-so. Upon questioning, they admitted that they were transporting drugs which was kept concealed within the secret chamber of gearbox of the aforesaid vehicle. They also confessed that as per instruction, an investment of the owner of the vehicle, namely Abu Muhammad so-and-so, transport search was concerned. Before conducting the search, one individual, namely so-and-so, who was summoned to act as a witness to the search and seizure process, was requested to conduct a body search and leave.
No, you have not understood my
So, my
question.
lord, my humble submission, there's police is saying that they're detained already, my.
No. You bring it on record. If this is your contention that you were detained during this period in the police station, where is the material? We cannot presume things.
police is saying that they're detained already.
Police is saying,
Police custody, my lord.
police is saying that you were arrested on
The next,
on
but
next
police
day.
is saying that they were.
How we will know that before your arrest you were kept under detention in police station? If you yourself do not disclose this fact before the court, what is the difficulty in disclosing that fact?
File an additional affidavit.
Yes, file it.
My.
Heard. Mr. H.R. Chaudhary, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. Learned counsel for the petitioner praise for allowing the petitioners to bring on record certain facts relevant for consideration of this this bail application by filing an additional affidavit. The prayer is allowed. Let this matter be listed when?
On my note, Tuesday.
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 31.
31.
Obliged.
Criminal matter orders, item 57 and 58.
Any report of service?
Alert service, not getting it. No, no, in the Rasulabad to appear in item 58, malad, name shown, malad.
No, in 57.
57 is a dispose of case, here only IA. I have not gone for that.
57 is important.
Malad, malad.
No, on last occasion,
I'm sorry, malad.
Mr. Locker appeared. A
Malad,
copy of order was, you go through the order.
malad, I'll go through and malad, I'll inquire in our office, malad, whether that 57 file also not getting, malad, because of that.
None has appeared for the applicant on call. Well, Mr. K. Parashar, learned additional public prosecutor, seeks some time to let this court know about the fate of the notice issued to respondent number 2 in this instant interlocutory application. The prayer is allowed. Let this matter be listed on 22nd April.
Item 59.
We'll take it up after
Well,
at 2.
Admission, item 2.
The records have been received. We'll admit it.
manual.
We'll admit the appeal.
File.
It is not yet admitted. It is against an injunction order.
Injection order.
That's order 43 rule 1.
Final injection order, my lord, passed after hearing both the parties.
Injunction was granted or rejected.
The injection granted.
Now, what is your submission? Should we hear it now or will
This
we-
can be hard and my lord dispose of file.
After some time, if you are accepted.
finally disposal? Then we'll take it up at 2. You are ready for final disposal.
No, after some time,
After some time means today or
not after some days.
after some days. Okay. Heard Mr. R.K. Jain, learned counsel for the appellant. Also heard Mr. N. Alam, learned counsel appearing for all respondents. it appears that this appeal is yet to be admitted, since the appearance of parties is complete and the trial court records have also been received. This appeal is listed. This appeal is admitted for hearing. List this matter for hearing when?
25th of April.
25th of,
April.
I will not be there, my lord. First week of May.
or else it will go to June.
First week of April, if
May.
possible. First week of
May first week. Second week.
Third, fourth May, my lord, if possible.
26th May.
March.
Item 3.
Yes, Mr. Alam.
My lord. Lordship was pleased to hear this matter, my lord, on the point of admission. But in view of preliminary objection raised by the learned counsel for the respondent, my lord. Regarding maintainability, my lord, this matter has been posted today. My lord, an issue has been raised before the Honorable Court in the light of section the Promotional Process.
Arbitration Act. Putul. Arbitration Act. And Commercial Court Act. Arbitration is like- Is it maintainable according to you?
My lord, I have prepared a brief synopsis, my lord.
Yes.
My lord, an issue. Yes, lord. May submit, my lord.
Yes.
My lord, an issue has been raised before this Home Court, my lord, in terms of, my lord, provisions of section 10(3) of the Commercial Court Act. Is this the court?
Section 8.
10(3), my lord, of Commercial Court Act.
Yes.
দেখুন দিয়ক না। In the light of, my lord, notification dated 13 to 19, my lord. Notification.
Commercial Court Act আছে। Yes. Yes.
Yes, my lord. My lord, section 13, attention has been drawn to this Home Court, my lord, regarding provision of section 13, my lord, of the Act of Commercial Courts Act of 2015, my lord. In the light of, my lord, section 37 of the Arbitration and Conciliation Act 1996, my lord. Drawing the attention of this Home Court, in terms of notification dated 30 to 19. My lord, notification dated 30 to, first of all, my lord, the Act of 2015 is a general law, my lord. General provision for speedy disposal of the commercial disputes, my lord. But Arbitration and Conciliation Act, my lord, is special legislation, my lord. Special legislation. And, my lord, this notification was issued in general, in respect of, my lord, disposal of the general disputes under Commercial Courts Act, my lord. So, my lord, provisions of section Act of 1996 having overriding effect over the general law, my lord, Commercial Courts Act. My lord, in this respect, my lord, I placed on record. The matter went to the appellate court, my lord, and this has been decided in 2018-14 SCC, page 714, my lord. In paragraph 22, your lordship may kind of to see where this is.
Which judgment?
This
In
is,
which
my lord, page 50 of my compilation, my lord.
page?
50, 50. And next, my lord, relevant para is 22 at page 68, my lord.
No, in page 50, what you want to?
Page
show?
50, my lord, this is the citation, my lord, 2018-14 SCC, my lord. Relevant paragraph is 22 at page 68, my lord.
What it says?
Page 68, my lord. I am reading.
Page 68.
68. Paragraph 22 of this particular judgment.
Yes. Yes.
My lord, I'm ready. Paragraph 22. However, the question still arises as to why section 37 of the Arbitration Act was explicitly included in proviso to section 13(1) of the Commercial Courts Act, which is equally a special provision of appeal contained in self-contained court, which may in any case would be outside section 13 of the Commercial Courts Act. On one answer is that this was done ex evidently secular. Another answer may be that as section 37 itself was amended by Arbitration Amendment Act 2015, which came into force on the same day as Commercial Courts Act, the Parliament thought in its wisdom that it was necessary to emphasize that the amended section 37 would have precedence over general provision contained in section 13(1) of the Commercial Courts Act. My lord, this is my submission, my lord. This act, Arbitration Act, is having precedence, my lord, over the Commercial Courts Act, my lord. Now, your lordship may kind of
The impugn order has been passed by which court?
by the Commercial Court of London Civil Justice.
Commercial court.
Commercial Court. Civil Justice Senior Division number 1 at Gauhati. Now, my lord, this home court is, with all respect, my lord, is required to be go through the definition contained in Act of 1996, section 2E, my lord. Courts. That is to be taken into consideration because, my lord, Supreme Court is has laid down the law, my lord.
No, but a division bench of this court has already held.
No, my lord.
No.
With all respect, my lord.
Okay.
My lord.
Make your submissions.
My lord, that judgment, my lord, which my lord colleague has referred, my lord, that in that judgment, my lord, the question of second appeal was involved, my lord. Issue of second appeal. Act of 1996, my lord, does not provide any provision for second appeal, my lord. That was decided in the judgment, my lord, of 23/4/2025, my lord, by the Honorable Division Bench of this Honorable Court, my lord. Not the issue of maintainability of appeal before this Honorable Court. Now, my lord, your lordship may kind of to see, come to page 71 of this particular judgment, my lord, last paragraph.
Yes. Yes.
Page 71, my lord, last sentence, my lord. Even on applying the doctrine of harmonious construction of both the statutes, it is clear that they are best harmonized by giving effect to the special statute, that is Arbitration Act, whether it is more general statute, namely the Commercial Courts Act, being left to operate in spheres other than arbitration. My lord, Commercial Courts Act has been enacted by the Parliament, my lord, for operating in commercial spheres, not in respect of arbitration proceedings, my lord. Next submission, my lord. Although, my lord, this was judgment of the Honorable Appellate Court prior to coming into force of the Act of 2015, my lord. But, my lord, question of deciding the forum has been laid down in this law, my lord. 2007, 1 SCC, page 465. The lordship may kind of to see, this is available. Page 89, my lord, relevant page is 101, my lord. Last page of my this compilation, my lord. Paragraph 32. Page 101, my lord. May I read it after?
Yes.
Paragraph 32, there exists a distinction between an appeal and an application, whereas section 31(4) of 1940 Act or section 42 of 1996 Act provides for an application. Subsection 2 of Section 37 of Act of 1996 provides for a statutory appeal. Lordship, this is most important, my lord. A forum of an appellate court must be determined with reference to the definition thereof contained in Act of 1996.
No, according to Arbitration Act, which is the forum?
My lord, as per
Forum.
section, as per definition of court, my lord, section 2E, my lord, the court of, principal civil court of original jurisdiction, my lord. For that purpose, my lord, herein in our state, my lord, the court of learned decision and decision is the principal court of original jurisdiction, because Honorable High Court does not exercise the trial power. So my lord, first appellate court is this honorable court, my lord.
How? No, let us go through the.
Furthermore, your lordship, I cannot see, I have also annexed. My lord, page 13 may kindly be seen of my this compilation, my lord. Page 13. Page 13. Page 17, my lord.
Yes.
Page 17, my lord. After coming into force of this Act of 2015, as well as, my lord, after coming into force of this notification of 13 to 19, my lord. Almost, my lord, 37 appeals under Section 34(7) has been 50 cases, my lord, under Section 37, my lord, of our Act of 1996 has been taken up by this Home Court, my lord, and disposed of. 50 cases, my
But
lord.
perhaps this issue was never raised in those cases.
But, my lord, this issue is required to be decided, my lord, on the basis of this, my lord. Even, my lord, your lordship, I cannot see, I have placed on record the order dated 18 to 2026, my lord. In regular way, my lord, all the appeals are entertained by this Home Court, my lord, in all cases, my lord. 50 cases have been disposed of, my lord. As of now, my lord, more than 6 appeals are pending before this Home Court, my lord. Page 2 of this compilation may kindly be seen, your lordship.
No, these 50 cases are from appellate.
Appeal,
From,
my lord,
no, from commercial courts.
yes, my lord. All other appeals under Section 37 in respect
But
of order.
that cannot be a submission before this court when the question of maintainability is
Well,
raised.
that's why, my lord, I am submitting, my lord, that Commercial Courts Act is a general provision, my lord. Arbitration Act is 1996 is a special provision. This act shall have overriding effect of the general provision, general law. That is my submission before lordship. Yeah.
Okay.
Get up to that.
No, you make me understand about Section 37, Clause 1 of the Arbitration Act. That appeal shall lie.
Not as entity quoted in any other law for the timing in force, and appeals shall lie from the following orders to the court authorized by law.
Court authorized by law.
To hear appeals from the original degree of the court passing the order, namely, my lord, refusing, that is, my lord, 37(1) is not
No,
applicable in our.
this line, these two lines, the court authorized by law to hear
the
appeal
appeals
from
the
original
degree of the
degree
court of passing.
of the court.
My lord,
Now, the
my-
order has been passed by a commercial court.
Commercial court, my lord.
So
lord, commercial
appeal
court-
would normally lie before the appellate division of the commercial court.
May I please, your lordship? My lordship, my lord, court has, matter has been taken up by the commercial court, my lord, for my lord, 37(1)(b), my lord, granting, allowing the application filed under Section 9.
No, that is okay.
My lord, now, my lord,
regarding forum.
forum, my lord, forum of appeal, my lord, in our state, my lord, has been notified by the Assam, Bengal Assam Agra Civil Courts Act, my lord. This is having appellate power only up to the extent of 20 lakhs.
No, no. When the order was passed by a commercial court,
My lord.
there is a appellate forum for,
My lord, appellate forum is, with all respect, my lord, I may be wrong, my lord, subject to satisfaction of lordship, my lord. Appellate forum is required to be considered in pursuance of Act of 1986, my lord, not in terms of commercial courts act, my lord. Because this is general law, my lord. Arbitration Act is special.
maybe,
special, my lord.
but it is passing order as a court, as a commercial court only, not as.
No, my lord, this is the, not dealing with matter commercial, my provision, my lord. Only on the, for the purpose of, my lord, deciding the section 9 application, my lord, court has been empowered. Specially, my lord.
Okay.
But, my lord, appellate forum is required to be decided, because, my lord, Act of 1990, Act of 2015, my lord, does not deal with the arbitration matters, my lord. Arbitration is, appellate forum is required to be taken into consideration under section 37, my lord. 37 says, my lord, appellate forum shall be dishonorable court, my lord. That's why, my lord, these appeals are entertained before the by the Supreme Court, my lord, in all cases.
Yes. Anything else?
My lord, one more judgment is there, my lord, within paragraph 25 is there. 2015, my lord, 1 SCC 32.
Page number? In your compilation, it is there.
My lord, page 72, my lord. And the relevant portion is, my lord. It's page 87, my lord. Page 87, my lord, paragraph 25. May I read, your lordship? Paragraph
Yes.
25, page 87, my lord.
Yes, what was the issue in this case which you are referring to? Yes, what you want to submit?
My lord, paragraph 25. Our conclusion, therefore, on section 21E, my lord, this is 21E relates to definition of court, my lord. And section 42 of the Arbitration Act 1996 are as follows. Section 21E contains an exhaustive definition marking out only the principal civil court of original jurisdiction in a district or a high court having original civil jurisdiction in the state and no other court for the purpose of part 1 of the Act of 1996. The expression with respect to an arbitration agreement makes it clear that section 42 will apply in all applications made whether before or during arbitral proceeding or after the award. However, section 42 only applies to the application made under part 1 if they are made to the court as defined. Since applications made under section 8 are made to a judicial authority, and since applications are under section 11 are made to the Chief Justice of or his designated, the judicial authority and Chief Justice or his designated not being the court as defined, such application would be outside section 42. Section 9 application being application made out to a court, and section 34 application to set aside arbitral award are applications which are within section 52. In no circumstances can the Supreme Court be called for the purpose of section 21E, and whether Supreme Court does not restrain seizing after appointing an arbitrator. Applications will follow the first application made before either a high court having original jurisdiction in a state or principal civil court having original jurisdiction in the district, as the case may be. So, my lord, herein the emphasis has been put on section 21E. And, my lord, if it is read in consolation, my lord, of section 37, then appellate forum is dishonorable court.
In this case, the subject matter of the
But my lord, definition of court was dealt with, my lord, whether trial court or appellate court, my lord.
no, subject matter of the arbitration is a commercial dispute in this case.
Yes, my lord.
So therefore, the matter was filed
Refer to the
before
court of original jurisdiction, my lord,
commercial court,
court, my lord.
which is a commercial court. So under 10 clause 3, your gist of your submission is that in respect of arbitration matter, the forum
Yes,
will,
right, it is-
forum will not be decided according to the
Commercial court.
Commercial Court
Commercial
Act.
court.
And it will be decided as per section 10 clause 3 of the, no, as per the Arbitration Act 1996.
1996, my lord, as per section 2E.
Yes, Mr. Dekar.
Lord, in fact, when that notification first came out, my lord, we had also argued on similar lines that section 2E of the Arbitration Act defines court to mean the principal civil court, in other words, the district judge, my lord. So any court inferior to that, to the court of district judge will not be competent to take up arbitration matters, my lord. Lord, while that challenge was pending, my lord, similar issue happened in Orissa also, my lord. Orissa also designated commercial court below the rank of district judge, and therefore that notification was challenged before the Supreme Court. That since civil judge would be below the rank of district judge, it cannot act as a principal civil court since arbitration is a special act. My lord, may kindly have paragraph 4 of that judgment, my lord, just to show what was the case, my lord. On that ground, the notification passed in Orissa was challenged. Then so far as arbitration matters are concerned, no court below the rank of district judge, though may have been designated as commercial court, can take up arbitration matters. Paragraph 4, my lord, if I may just read.
Yes.
It was the case of the appellant original writ petitioner that constituting and or designating the courts of civil judge senior division as commercial courts and to exercise powers under the Commercial Courts Act would be in conflict with the provisions of section 21E of the 1996 Arbitration Act. It was the case of the appellants here that section 21E of the 1996 Arbitration Act, only the principal civil court of original jurisdiction in a district shall be court for the purpose of deciding the disputes under the 1996 Arbitration Act. And in case of an arbitration, it does not include any civil court of a grade inferior to such principal district judge. Therefore, it was a case on behalf of the appellants that to confer jurisdiction upon the Court of Civil Judge Senior Division to exercise the powers of Commercial Courts Act, including the proceedings under 1996 Arbitration Act, would be contrary to section 21E of the 1996 Arbitration Act, which is a special act. By the impugned common judgment in order, the High Court has dismissed the writ petition, which has given rise to the present appeal. Now, if your lordship has paragraph 24, my lord. My lord, it was taken note of that the section 21 of the Commercial Courts Act gives overriding effect. Section 21 of the Commercial Courts Act. My lord. Now, and finally, at para 24, this issue was dealt with.
Yes.
Does the object and reasons of the Commercial Courts Act 2015 is to provide for speedy disposal of the commercial disputes, which includes arbitration proceedings. To achieve the said object, the legislature in its wisdom has specifically conferred the jurisdiction in respect of arbitration matters as per section 10 of the 2015 Act. At this stage, it is required to be noted that the 2015 Act is the act later in time. And therefore, when the 2015 Act has been enacted, more particularly section 3 and 10, there was already a provision contained in section 21E of the 1996 Act. As per the settled position of law, it is to be presumed that while enacting the subsequent law, the legislature is conscious of the provisions of the Act prior in time, and therefore the later act shall prevail.
As regards forum also.
As regards forum also. So 21, given that 21 has overriding effect, I agree, Malad, they may not seem to be in tandem consonance because 21E defines the court as principal civil court. But Supreme Court held since 2015 came later, and there is a presumption that legislature already knows what earlier laws it has drafted. So therefore, the subsequent act will prevail, Malad. Now, if your lordship has the Commercial Courts Act for a moment, Malad. The prior sections would make it clear. Right?
Yes.
Section 3, first of all.
Yes.
Now it says section 3, subsection 1. The state government may, after consultation with the concerned High Court, by notification, constitute such number of commercial courts at, it says, district level, as it may deem necessary for the purpose of exercising the jurisdiction and power conferred on those courts under this act. So word used is district level. Now there is a proviso to it. It says, provided that with respect to the High Courts, having original civil jurisdiction, the state government may, after consultation with the concerned High Court, by notification, constitute commercial courts at the district judge level. At the district judge level. So for states where High Courts exercise ordinary jurisdiction, civil jurisdiction, it'll constitute commercial courts at district judge level. Subsection 1, the word district judge, the word judge is missing. So it says only district level.
But here it is, and commercial court has been, civil judge has been designated.
Yes. Now, the following sections will make it more clearer, my lord. Now, if your lordship may skip over to 3A now, this was added in 2018. Designation of commercial appellate courts. So for states with High Court under section 3, it can constitute commercial courts at district judge level, whereas other states can constitute it at district level. Now 3A says, except the territories over which the High Courts have original civil jurisdiction, the state government may, after consultation with the High Court, by notification, designate such number of commercial appellate courts at district judge level as it may deem necessary for the purpose of exercising the jurisdiction and powers conferred on those courts by under this act. So for other states, my lord, the appellate court will be at district judge level.
Okay.
Now 4 says, 4 is again dealing with states where High Courts exercise original
Other state means where the High Court exercises original jurisdiction.
Yes. So where states where High Courts exercise original jurisdiction, in those states, the commercial court itself, that is the trial court, will be set up at the district judge level. And for other states, it will be district level. Now 3A is saying that for courts, for states where High Courts do not exercise district judge, original civil jurisdiction, since you have constituted courts at the district level, the commercial appellate court will be district judge level. That is 3A. Then 4, my lord.
Which has been done in the case of Assam.
In the case of Assam, it has been done as per 3.1 and 3A.
Okay.
So since in Assam, High Courts do not exercise original jurisdiction, the trial, that is the commercial court, is set up at district level. The commercial appellate court is set up at district judge level, if I've understood it correctly.
Okay.
Now, if your lordship has 4 again, now 4 again is dealing with other states. The other category of states. In all High Courts having ordinary original civil jurisdiction, the Chief Justice of the High Court may by order constitute commercial division having one or more benches consisting of single judge for the purpose of exercising jurisdiction and powers conferred on it under this act. Now, this
This is not, no application in.
this has actually no application, but curiously, there is a notification appointing a particular bench as a commercial insofar as our High Court is. But this was perhaps not necessary because 4 is clear. But be that as it may, there is a notification. Now, section 5, my lord.
Yes.
Constitution of Commercial Appellate Division. After issuing of notification under subsection 1 of section 3 or under subsection 1 of section 4, the Chief Justice of the concerned High Court shall by order constitute Commercial Appellate Division having one or more division benches for the purpose of exercising jurisdiction and power conferred on it by the Act.
Okay.
Now it says section 4. So this again, section 5 again is
Other.
for other
Other
high courts.
state.
However, there is yet another notification of our High Court also appointing a particular bench as Commercial Appellate Division. Yes, this is of 23. So now, 2 more sections I'll quickly show, my lord. Section 10, subsection 3, my lord.
Yes. Yes.
1 and 2, we are not concerned. They are pertaining to commercial, international commercial arbitration. Subsection 3, if such arbitration is other than an international commercial arbitration, all applications or appeals arising out of such arbitration under the provisions of the Arbitration and Conciliation Act that would ordinarily lie before any principal civil court of the original jurisdiction, which happened earlier, in a district not being a high court, shall be filed in and heard and disposed of by the commercial court exercising territorial jurisdiction over such arbitration where commercial court has been constituted. So this also takes care of that phrase of principal civil court, which would ordinarily have been instituted before the district judge, would now be instituted before the commercial court.
No, this relates to applications or appeals.
Yeah, this relates to applications or appeals. Now, finally, appeals are separately dealt with at section 13.
Section
13, 1-3.
Yes.
Now, section 13 said, any person aggrieved by the judgment on order of a commercial court below the level of a district judge, that is our case, my lord, may appeal to the commercial appellate court. Because commercial appellate court then would be under, at the level of the district judge as per section 3A, which is applicable to us. And then there is 13(1)A. Any person aggrieved by the judgment or order of a commercial court at the level of district judge. So this is not our category. Exercising original civil jurisdiction as the case may be, or commercial division of a high court may appeal to the commercial appellate division of the high court. So 13(1) is.
Your submission is 13(1) covers.
13(1) and 3A is what covers us. 13.1 read with section 3A.
And
Insofar as and 13.1A will have no application because 13.1A is sort of relatable to section 4. Section 4 and 5.
and as per 3A, High
Yes.
Court has issued notification
Designating
district
civil-
judge
uh,
as the
Yes.
appellate.
Civil judges, commercial, district judges, which
appellate.
notification I had shared on the other day. Send me a job, but it's there on record. We have. So therefore, my lord, since
Yes, anything else?
no, that is all, my lord. So in our state, my lord, if I've understood it correctly, it'll be at district level, meaning below the rank of district judge, commercial court, at the rank of senior civil judge, senior division.
Before the division bench judgment which you have relied, the issue was different issue.
Yeah, that because your lordship posed the query, what happens to the commercial appellate division? So in that division bench judgment, what had happened was they filed a section 9 before civil judge senior division, then an appeal under 37 before the district judge, and then they preferred yet another appeal before the commercial appellate division, saying that since there is a commercial appellate division here, a second appeal may lie. Then
There the court held that before commercial appellate division, appeal lies only from commercial division of the High
division,
Court.
and regardless of whether we have constituted or not, you can't.
So that is not applicable to the facts of the
In this case, no, that
incident.
is only for the proposition that just because there is a commercial appellate division doesn't mean that an appeal not conceived of under the Arbitration Act and the Commercial Courts Act read together would be given right more.
Okay, anything, Mr. Alam?
My lord, section 3 clearly provides, clearly shows, my lord, that appeal shall lie 3A, my lord, commercial appellate court, my lord. So High Court has been mentioned, my lord, except the territories over which High Court have original civil jurisdiction. The state government may, after consultation with the concerned High Court, by notifying designate such number of commercial appellate courts at district judge level as it may deem necessary for the purpose of exercising jurisdiction and powers on those courts under this act, my lord. Under this act. My lord, our dispute is not in respect of, my lord, covered only by the Act of 2015, my lord. These are disputes covered by the Act of 1986, my lord. Furthermore, my lord, trial court has not registered our dispute as commercial dispute. This has been registered as mis-arbitration application.
Yes, on that,
Mis-arbitration application, my lord.
that this arbitration,
No, that has been taken care of in that judgment which I've said. Because there in fact, I did not place the entire judgment. There, in fact, the Law Commission's report was also discussed, and it was also that the issue of arbitration was also taken up. 2023 1 SCC 549. 549.
yeah,
Para 16 onwards, my lord. And before that, my lord, there's section 10 also, which says that now arbitration would be a commercial dispute. Before I place the paragraph, may I just read section 10 once more? Jurisdiction in respect of arbitration matters. Of course, if it's a family dispute, a family arbitration, then it may not apply, my lord. But here, my lord, it says where the subject
No,
matter of an
how
arbitration is a commercial dispute.
how you are saying that the dispute involved is a commercial dispute?
My lord, it-
In the arbitration,
my lord,
the dispute involved is a commercial dispute.
my lord will have the definition of commercial dispute, my lord. Section 2C, Roman 15, my lord.
Yes.
And that issue of jurisdiction was never raised, my lord. If it were not a commercial dispute, my lord, then I could not have approached the Court of Civil Judge at the first place, my lord. That was never their case, my lord, that it is not a commercial dispute.
Okay.
So section 10 again says that where the matter or subject matter of arbitration is a commercial dispute, then of a specified value, then this act will come into play, and the court designated under this act will take it up.
Okay, you wanted to show something.
Para
from the judge.
16 of that JC promoters, yes, JC housing, I'm sorry.
Yes.
Lord, we'll have para 20 straight away, the Law Commission's report. This act was framed keeping in mind the scheme of arbitration. Para 20. The Law Commission in its 253rd report submitted in January 2015 suggests a new approach for expediting commercial disputes and therefore proposed a new law. The Law Commission made the following recommendation qua arbitration matters involving commercial disputes. 3.24.4. Second, in the case of domestic arbitration concerning commercial disputes of more than rupees 1 crore, applications or appeals may lie either to the High Court or a civil court, not being a High Court, depending upon pecuniary jurisdiction. It is recommended that all applications or appeals arising out of arbitration and arbitrations under the Arbitration and Conciliation Act that have been on the original side of the High Court shall be heard by the commercial division of the High Court, where commercial division is constituted. However, in the absence of commercial division being constituted, the regular bench of the High Court will hear such applications or appeals arising out of domestic arbitration. If application or appeal in such domestic arbitration is not within the jurisdiction of the High Court and would ordinarily lie before a civil court, not being a High Court, and there is a commercial court exercising territorial jurisdiction in respect of such arbitration, then such application or appeal shall be filed in and heard by the commercial court. So based on this Law Commission's report, my lord, eventually 2015 came in, and secondly, the amendment of 2018.
Okay. Heard. Yes.
One submission, Your
Yes.
Lordship. In respect of, drawing the attention of section 1 and 2, those are not applicable in respect of our
Section?
case. Section 10, 1 and 2 of Commercial Codes Act, my lord.
Yes.
These are related to international arbitrations, my lord. Only section 10(3) is applicable in respect of our case. Wherein, my lord, this has been laid down.
That is his
Then-
submission also. He is also, sir.
Yes, sir.
That section 3 is
Applicable,
10(3) is applicable. Heard Mr. N. Alam, learned counsel for the appellant. Also heard Mr. B.D. Baker, learned counsel for the caviators / respondents on the question of maintainability of this appeal. On Tuesday, I will deliver judgment.
Much.
Tuesday, let this matter be listed on 31(3) for orders on the question of maintainability.
Obliged.
Delivery of orders, for delivery of orders.
Item 4.
For delivery of order. Yes,
Appellate Lordship, Lordship, appeal for enhancement Lordship. This an appeal Lordship under section 30 of the Employees Compensation Act Lordship. Lordship kindly see page Lordship 6 Lordship. Constitutional question of law Lordship. Page 6.
yes, but what is your case?
Lordship.
Whether undisputed monthly salary or third, Miss, what is your name?
They after.
J. Akhtar Lanet, Counsel for the Appellant. This appeal under section 30 of the Employees Compensation Act, 2023 has been preferred by the appellant Ulesha Begum, impugning the judgment and award dated 19/1/2026 passed by the Learned Commissioner, Workmen's Compensation Bongaigaon in EC case number 18/2025. After considering the memo of appeal as well as submissions made by Learned Counsel for the appellant, following substantial question of law is formulated in this appeal within inverted comma, whether the impugned judgment and award passed by the Commissioner Employees Compensation Borpeta Bongaigaon is perverse in not taking into consideration the undisputed, uncontroverted evidence regarding income of the deceased while awarding the compensation. Stop. Issue notice to the respondent and call for the records of EC case number 18/2025 from the from the Employees Compensation, from the Office of the Commissioner Workmen's Compensation Bongaigaon. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 15th of May.
Item 5.
It pleases your lordship. It pleases your lordship. My lord, the appellants have filed this appeal challenging the order passed by the learned court, civil judge, Vishwanath District, partly allowing my injunction application. So, my lord, what had happened was, I, being the daughter of late Bibin Bhuya, had filed a suit for partition against my brother, as well as the subsequent purchaser and my sister. The property in question, my lord, there are 4 folds on which we had filed this entire suit, my lord. First was that the patta was issued in the year 2006, October month, and immediately thereafter, the names of my brothers were only mutated in respect of the suit property. And subsequent thereto, in the next month, my lord, without following the mandate 10-year period wherein the property cannot be sold out, they had sold it to the defendant number 4, my lord. Now, why we have approached this honorable court? However, my lord, the injunction is partly allowed. constructions were being carried out on the property. If I may kindly take your lordship to the injunction application.
No, no, what relief was granted?
My lord, the opposite parties were restrained from creating any third party rights. However, the learned court had allowed them to make constructions. Now, why we?
That you are
My lord,
aggrieved.
Yes, my lord, not entirely, my lord. They have made constructions of temporary natures in the form of CI sheets, my lord. Why we seek an injunction on today's date is that, my lord, no constructions of permanent nature may not be done, my lord, during.
No, not without issuing. We are issuing notice. No interim at this stage.
My lord.
Heard, Mr. What is your name?
My lord, A. Bhatra.
A. Bhatra, learned counsel for the appellant. This appeal. Where is the memo? This appeal under order 43, rule 1R, 1 within bracket R, small r of the Code of Civil Procedure 1908 has been filed by the appellant Hemlata Bhuya, impugning the order dated 24/9/2025 passed by the Court of Learned Civil Judge Senior Division Bishwanath in Ms. J case number 8/2025 in connection with title suit number 12/2025, whereby the application filed by the present appellant under Order 39, Rule 1 and 2 of the Code of Civil Procedure 1908 was partly allowed. I have gone through the memo, grounds taken in the memo of appeal, and have considered the submissions made by learned counsel for the appellant. This appeal is admitted. Issue notice to the respondents and call for the scanned copy of the records of Ms. J case number 8/2025, along with scanned copy of the records of title suit number 12/2025 from the trial court. The registry shall take steps for requisitioning the scanned copy. Issue note, the appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 15th of May. You have interlocutory application also. Issue notice. Issue notice in the IA also.
Item 6.
It is a lordship. Lordship, both the parties here, lordship, actually wanted to settle this matter in low court level. In fact, I was given this authority by the company also. But
What
the
happened?
other party could not come, they could not be listed. Today, can it be done, lordship? We give an affidavit to them. We have waived the interest, lordship, the principal.
Now, what has been agreed?
Let's say that 17,85,360, that's the award itself without the interest.
You are agreeable?
Yes. Yeah, in fact, this may also be kept in record, my party. I can sign this one also. Yes, that was given to me. But because the claimant could not come, I didn't file it also.
Heard Mr. R. Goswami, learned counsel for the appellant. Also heard Mr. A.R. Agarwala, learned counsel for the claimant's respondent. It is submitted at bar that the matter has been amicably settled between both the parties and it has been agreed that the appellant insurance company shall pay a compensation amount of rupees 17,85,360 to the claimants without any interest component. Stop. You are not filing any written.
In fact, it remained after because it was supposed to be placed before local law. And then it came up. We have given affidavit to them, Lordship.
In fact, he had given an claimant had
Affidavit.
filed an affidavit, they did copy to us.
Affidavit is,
By the claimant.
By the claimant,
Yeah,
authorizing the
it is,
company. Saying they are.
in the record,
No, Lordship.
you give a copy, you keep the original, give a copy.
The company had said.
We can give it. That I do.
It can.
Learned counsel for the claimant, respondent has submitted a copy of an affidavit sworn by the claimants, wherein they are agreeable to waive the interest component on the awarded compensation. So accordingly, this appeal is disposed of on composition in terms of the aforesaid agreed compensation amount to be paid by the appellant to the claimant's respondent. Stop. The insurance company shall pay the aforesaid amount when, where
Registered.
shall pay the aforesaid amount.
Here claimant number 1 is the mother and claimant number 2 is the father, Lordship. So father is only given this conventional heads, 88,000, Lordship. So if the entire amount and mother.
No such observation.
Then minor's fee may be kept as per the order and wife.
Where is the order?
The page number, Lordship.
Page number 18, Lordship.
Minus 3 lakh each fixed deposit.
No, it shall be according to the judgment, whatever has been.
No, Lordship, but the mother is the major, Lordship. Mother's 3 lakhs may not be paid, kept as fixed deposit, Lordship. And minors, brother, sisters only, 2 sisters. So their amount may be kept as fixed deposit, 3 lakhs each.
Stop. It is further submitted by learned counsel for the claimant respondent that by the impugned judgment of the tribunal, the share of the compensation of the claimant number. Who is the mother?
Mother is the claimant number 1. Lordship.
What is her name?
Panchami Sangha. Panchami Sangha. The son died, mother and father and 2 sisters.
Share of the compensation of the claimant number 1, namely Panchami Momin, was directed to be kept in any bank as fixed deposit. However, he submits that
3 lakhs only, entire share is not there. Only 3 lakhs.
since no, why let it be there for 5 years?
No problem.
No, he cut it off.
It's for the judgment.
The amount shall be disbursed to the claimants in person to the observation made by the Motor Accident Claims Tribunal, Gwalpara, in paragraph number 32 of the impugned judgment. The
Lordship, I would like to take leave, Lordship.
Lordship, 31 and 32.
31 and 32 of the impugned judgment. The appellant insurance company shall deposit the awarded amount before the registry of this court within 4 weeks from the date of this order. Same shall be dispersed by the registry to the claimants in person to the observation of the Motor Accident Claims Tribunal, Gwalpara, made in paragraph number 31 and 32 of the impugned judgment. This MAC appeal is accordingly disposed of.
Statutory deposit.
The statutory deposit deposited by the appellant at the time of filing of this appeal shall be returned back to the insurance company after proper verification. I stand disposed of.
Item 7.
Lordship, this is an statutory appeal, Lordship, challenging the quantum. In this case, Lordship, major earning sons and married daughters are claiming compensation for the death of father, Lordship. But evidence says that the sons are working and earning, Lordship. So there is no loss of dependency in this case, Lordship. That is our main ground of appeal.
Heard Mr. A.J. Sakya, learned counsel for the appellant. This appeal under section 173 of the Motor Vehicle Act 1988 has been preferred by the United India Insurance Company Limited, impugning the judgment and award dated 12/11/2025 passed by the Motor Accident Claims Tribunal, Dhubri, in MAC case number 102/2022. Within bracket D. The appellant is aggrieved mainly with the quantum of compensation awarded to the claimants. The appeal is admitted. Issue notice to the respondents. The appellants shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 18th of May. Let the record of MAC case number 102/2022 be called for from the concerned tribunal. List accordingly. In IA, we are issuing notice. Let the other side appear.
We are ready to deposit 50% Lordship without release.
No, then we are not granting now. Let the other side appear. Issue notice.
Item 8.
My pleasure, Lordship. Lordship, the appeal is filed against the judgment dated 26/11/2024, passed by London member MACT Chirang, passed in MACT case number 2 of 2022. Impugned judgment is
What is your name? What is your name?
KK Medhi. I am appearing on behalf of my
Heard Mr. KK Medhi, learned counsel for the appellant. This appeal under section 173 of the Motor Vehicle Act 1988 has been filed by the appellants, impugning the judgment and award dated 26/11/2024, passed by the Motor Accident Claims Tribunal, Chirang, in MAC within bracket D, case number 2/2022, whereby the appellants were directed to pay compensation amount of rupees, how much? 12,94,359, along with interest at the rate of 6% per annum to the claimants. I have gone through the grounds stated in the memo of appeal and have considered the submissions made by learned counsel for the appellant. Stop. This appeal is admitted. Issue notice to the respondents. Let the records of MECD case number 2/2022 be called for from the concerned tribunal. Let also notice be issued to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days of the date of this order, returnable on 18th of May.
Deeply.
Item 9.
Lordship, this case is also filed against Lordship Quantum. In this case, on the basis of temporary disablement certificate, the learned tribunal had considered the same to be permanent disablement. So amount is given in the higher side.
Okay. Okay. Heard Mr. A.J. Soikyal. ये सेम ऑर्डर होगा. Issue notice, same order. 18th of May.
Stay same order.
Say same order. Issue notice.
Item 10.
So appealed by the insurance company on the ground that deceased was a government employee and the family members should get a full salary till the return. That is the ground. So file this appeal, but tribunal has awarded loss of dependency at rupees 39,17,487. So as per judgment of the Supreme Court, they are entitled for rupees 2,41,538. We are going to deposit that amount. Page 23. Under the conventional head, they are entitled to 2,14,538.
Under what?
Conventional head, medical expenditure, loss of dependency,
Okay.
and conventional head, total 2,14,538.
Heard Mr. S.K. Goswami.
Lordship,
Yes.
because now latest judgment on the Supreme Court has come, the insurance company has to deposit the full amount, Lordship, for the salaried person, Lordship. And after that.
No, let us admit this. We'll
Yes, Lord. Okay, no problem.
heard Mr. S.K. Goswami, learned counsel for the appellant. Also Mr. A.R. Agarwala, appearing for the caveator / respondent number. Respondent number
1, 2, 3, 4.
1, 2, 3, and 4 / claimants. This appeal under section 173 of Motor Vehicle Act 1988 has been preferred by the Oriental Insurance Company Limited, impugning the judgment and award dated 3/1/2026, passed by the Motor Accident Claims Tribunal number 1, Kamrup Metro, Gauhati in MEC case number 332/2018, whereby the appellant was directed to pay a compensation amount of rupees 39,12,487 along with interest to the claimant's respondent. I have considered the grounds taken in the memo of appeal and also considered the submissions made by learned counsel for the appellant. This appeal is admitted. Issue notice to the respondents and call for the records of MEC case number 332/2018. The registry to take steps for requisitioning the records. the appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode
5 and 6 only. Lordship.
with the as well as the usual mode to respondent number 5 and 6
Requisite extra.
within 7 days from the date of this order, returnable on 18th of May. Since Mr. Agarwala has already appeared for respondent number 1, 2, 3, and 4, no formal notice need to be issued. However, the appellant shall furnish requisite number of copies of memo of appeal along with annexures to the learned counsel for the respondent number 1 to 4 list accordingly.
A petition Lordship.
You have any objection?
No, Lord, 50% is will deposit, will know to draw.
You have filed any execution case?
No, yes, Lordship, I have not filed execution case, but. the
You have not filed?
No.
Then you file objection against this. We are issuing notice. We are not staying it now. Because their contention is that you are not entitled to get more than 2 lakh something. So,
Lordship, Lordship may not state, we will be, my submission will record it. We are going to deposit rupees 2,14,538. We'll deposit within 4 weeks, Lordship. Lordship may record that.
Para number, page number 20 of the.
Page 23, Lordship.
okay, no, today we are not staying.
I'm not saying stay. Lordship.
Okay, heard Mr. S.K. Goswami, learned counsel for the applicant. This interlocutory application under Order 41, Rule 5 of the Code of Civil Procedure has been filed, filed by the applicant insurance company in connection with the MAC appeal number 132/2026. Praying for stay of execution of the judgment and award dated 3/1/2026 passed by the Motor Accident Claims Tribunal number 1 Kamrup Metro, Gauhati in MAC case number 332/2018, whereby the applicant was directed to pay a compensation amount of rupees
Page 23.
39,12,487 along with an interest at the rate of 6% per annum thereon. Learned counsel for the applicant has submitted that in the connected memo of appeal, the applicant has taken a ground that since the deceased was a service holder and the dependents of the deceased would get full salary during the remaining period when he would have been in service as per the new notification. New notification issued by the government of Assam in that regard. There is no loss of dependency as calculated by the Motor Accident Claims Tribunal. He submits that the claimant would only be entitled to compensation under conventional heads, which would amount to rupees
14,538.
14,538. He submits that the applicant is ready to deposit the said amount as a condition for grant of stay of the impugned judgment and award. However, Mr. A.R. Agarwala has opposed to the said submission and has prayed for some time for filing written objection against the prayer for stay. He submits that he is ready to concede to the prayer of grant of stay if 50% of the awarded amount is deposited, to which the learned counsel for the applicant is not agreeable to. Hence, let this case be listed along with the connected MAC appeal on 18th of May. In the meanwhile, the
I have not received any copy for the state.
in the meanwhile, the claimant respondent may file their written objection.
Also, we may be given liberty because otherwise you have to pay the burden the interest. So we'll deposit this amount to the registry. This is my,
No, Lordship, because they will be losing the interest. So what is the mode of
we'll
deposit?
deposit the amount before the registry will keep.
Because it is a money decree.
No, suppose this prayer for
If Lordship will allow, consider their prayer on 18 and Lordship directed to deposit some amount, we'll deposit. But at this moment, we will deposit this amount and registry will keep this amount in fixed deposit.
No, Lordship, registry is not doing that, Lordship. It's
We-
not doing that.
no, let us wait for 18th March.
I have no objection to that. If he's,
Copy may kindly be given.
we'll give the copy today itself.
The
Copy is not given, stay copy.
the learned counsel for the applicant undertakes to furnish the copy of the interlocutory application along with the annexure and the memo of appeal
Today itself, Lordship.
today itself to the learned counsel for the claimant respondent, list accordingly.
Obliged.
Item 11.
Yes,
Yes, it's a decision appeal filed by the insurance company.
heard Mr. K.K. Bhatto, learned counsel for the appellant. This appeal under section 173 of the Motor Vehicle Act 1988 has been preferred by the National Insurance Company Limited, impugning the judgment and award dated 18/12/2025 passed by the Motor Accident Claims Tribunal Gauhati in MAC case number 308/2018, whereby the appellant was directed to pay a compensation amount of rupees 11,38,000 along with an interest at the rate of 7.5% per annum to the claimant's respondent. I have gone through you are challenging the quantum
No, Lordship.
liability. I have gone through the grounds taken by the appellant in the memo of appeal and have considered the submissions made by learned counsel for the appellant. Stop. This appeal is admitted. Issue notice to the respondents and call for the records of MAC case number 308/2018 from the concerned tribunal. Registry to take steps for requisitioning the records. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 15th of May. I is there. I will issue notice.
We'll deposit 50%, let them not be allowed to withdraw. We'll deposit, let them.
Heard Mr. K.K. Bhatto, learned counsel for the applicant. This interlocutory application has been filed by the applicant insurance company in connection with MAC appeal number 133/2026, praying for stay of execution of the judgment and award dated 18/12/2025 passed by the Motor Accident Claims Tribunal Gauhati in MAC case number 308/2018, whereby the applicant was directed to pay a compensation amount of rupees 11,38,000 along with an interest at the rate of 7.5% per annum to the claimant respondent. Stop. Since the learned counsel for the applicant has submitted that the insurance company is ready to deposit 50% of the awarded amount as a condition for grant of stay of execution of the impugned judgment and award, comma, the notice to the respondents is waived. Respondents in this interlocutory application is waived. And the instant interlocutory application is allowed. The execution of the judgment and award dated 18/2/2025 passed by the Motor Accident Claims Tribunal Golpara in MSC case number 308/2018 shall remain stayed during the pendency of the connected MAC appeal number 13/2026, subject to deposit of 50% of the awarded amount by the insurance company applicant before the registry of this court within a period of 6 weeks from the date of this order. This interlocutory application is accordingly disposed of.
Item 12.
May I please, your lordship? Lordship, statutory appeal under section 173 of LBR.
Heard Mr. A. Brahma, learned counsel for the appellant. This appeal under section 173 of the Motor Vehicle Act 1988 has been preferred by the appellant claimants. You are aggrieved with the quantum or dismiss?
What do you call quantum loss?
Quantum. Appellant / claimants impugning the judgment and award dated 11/11/25 passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro at Gauhati in MSC case number 1653/2022. So the appellants are aggrieved mainly with the quantum of compensation awarded to them by the impugned judgment. I have considered the grounds mentioned in the memo of appeal by the appellants and have also considered the submissions made by learned counsel for the appellant. Stop. This appeal is admitted. Let the records of MSC case number 1653/2022 be called for from the concerned tribunal. The registry shall take steps for requisitioning the records. Stop. Let also notice be issued to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 20th May. List accordingly.
Item 13.
Wait, this is your lordship. This is an statutory appeal, lordship. Appeal is filed, lordship, because the policy was a private car liability only policy, and the person was traveling inside the vehicle, lordship. So the liability ought to have been present on the owner, not on the insurance company, lordship. That is main ground, lordship. Other than that,
Heard Mr. R.D. Majumdar. Heard Miss R.D. Majumdar, learned counsel for the appellant. This appeal under section 173 of the Motor Vehicles Act 1988 has been preferred by the Oriental Insurance Company Limited, impugning the judgment and award dated 21/2/2025 passed by the Motor Accident Claims Tribunal, Lakhimpur, North Lakhimpur, in MSC within bracket death case number 7/2020 whereby the appellant was directed to pay a compensation amount of rupees 19,14,723, along with an interest at the rate of 6% per annum to the claimant's respondent. I have gone through the grounds taken in the memo of appeal by the appellant, as well as also considered the submissions made by learned counsel for the appellant. Stop. This appeal is admitted. Let the records of MSC case number 7/2020 be called for from the concerned tribunal. Let also the notice be issued to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 20th of May.
We have a stay also, Lordship.
We issue notice now.
Then Lordship, let it be there. Let them appear.
Let them appear.
I'll oblige.
Orders, item 16.
Lordship, in this case, insurance company and claimant has agreed to settle the case, Lordship, at rupees 13 lakhs.
I is for
Lordship, IA was for delay condonation, Lordship.
the delay has to be called.
Delay in preparing the appeal, Lordship. That is yet to be.
But settlement, can it be where I will pass the order? There is no appeal pending now.
Yes, appeal is not pending now.
Say, delay has to be first condoned. Appeal has to be registered and
Appeal
then
is already registered, Lordship.
appeal is registered
Registered, 672/70.
without condoning delay.
Yes, at that point of time in 2017, the practice was like that.
Okay, then we'll condone the appeal some asene. It is listed also. In IA pass, IA likhibo. Heard Mr. A.J. Soikia, learned counsel for the applicant. Also heard Miss, what is the name?
M. Chetia.
M. Setia, learned counsel for respondent number
1.
1. There is only one claimant.
One claimant.
Respondent number 1 claimant. This interlocutory application has been filed by the applicant under Section 5 of the Limitation Act for condonation of the delay of 23 days in preferring the connected appeal. Stop. It is submitted at bar that the matter has already been amicably settled between the parties and the claimant respondent does not have any objection if the delay is condoned. Stop. Accordingly, the delay of 23 days in preferring the connected appeal is hereby condoned and this interlocutory application is allowed. In make appeal likhibo. This appeal under Section 73 of heard so and so both parties. This appeal under Section 173 of Motor Vehicles Act 1988 has been preferred by the Reliance General Insurance Company Limited, impugning the judgment and award dated 26/7/2017 passed by the Motor Accident Claims Tribunal, Jorhat, in MSC case number 63/20/2010 whereby the appellant was directed to pay a compensation amount of rupees 15,64,800.
It's 50% of that amount. Two vehicles were involved also.
Hmm?
50% of that amount. Two vehicles were involved also in the accident. Other vehicle was held liable to 50%.
Illegally. How much? What was the awarded amount?
Lordship, 15,64,800.
क्या लिखा last line? Pay 50% of the total awarded amount of rupees 15,64,800, which otherwise it comes at about 8 lakhs only.
Yes, Lord.
But you are agreeable to pay 13 lakhs.
The interest is there, 2010.
Oh, okay. Stop. It is, since it is submitted at bar that this matter has been amicably settled between the parties, hence between the parties within bracket insurance company and the claimant, hence notice to other respondents is hereby waived. Learned counsel for the appellant as well as claimant respondent has submitted that this matter has been amicably settled between the parties at a agreed compensation amount of rupees 13 lakhs to be paid by the appellant insurance company to the claimant / respondent number 1 without any interest. This is the lump sum amount. 13 lakhs. It is also submitted by the learned counsel for the appellant. You are agreeable to it?
Yes, my lordship.
Learned counsel for the appellant as well as learned counsel for the claimant that this appeal may be disposed of in terms of the agreement arrived at between amicably settled agreement arrived at between the parties. Stop. Accordingly, this appeal is disposed of in terms of the amicable settlement arrived at between the parties, and the appellant insurance company is directed to deposit and pay the agreed compensation amount of rupees 13 lakhs to the claimant / respondent number 1 within a period of 4 weeks from the date of this order. The said amount shall be deposited where?
Registry, Lordship.
Before the registry of this court within the period of 4 weeks. And on such deposit, same shall be dispersed to the claimant / respondent number 1 by the registry after proper verification. This appeal is accordingly disposed of.
Lordship, statutory amount not.
The statutory amount deposited by the appellant at the time of filing of this appeal shall be returned back to the appellant after proper verification.
Another IA is also there, Lordship, that was for state, that may also be closed, Lordship.
This IA 4344 stand close in view of the disposal of the connected MSC appeal.
Item 17.
Please, your lordship. Lordship, service is not completed, lordship. Awaited service.
How many respondents are there?
3 respondents, lordship.
I am for respondent number 3, Lordship, in this case.
On whom service is not complete?
Which 1, 2?
Okay, what is your name?
Are they appearing on behalf of AJ Ghosh?
Heard Miss R. Deb, appearing on behalf of Mr. A.J. Ghosh, learned counsel for the appellate. Also heard Mr. A.J. Swakya, learned counsel for respondent number 1. It appears from office note dated 24/3/2026 that notice to when have you taken steps?
Date not.
Notice to respondent number 2 and 3 have not yet been returned.
I am 3, Lordship.
Notice to respondent number 1 and 2. On 2, you have not taken steps. 1 has not returned. The registry is directed to place the postal track consignment report of notice issued to respondent number 1 by way of speed post on the next date fixed. The appellant is also directed to take fresh steps for issuance of notice upon respondent number 2 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 13th of May.
Item 18.
Yes.
I have taken step through paper publication. For filing appeal, I am paying 1 week time to.
Heard Mr. K.K. Bhatto, learned counsel for the appellant. Also heard Mr. R.K. Mahanta, learned counsel for the respondent number 1. Learned counsel for the appellant submits that the appellant has taken steps for issuance of notice by substituted mode of newspaper publication and seeks a week's time for filing affidavit in compliance that the prayer is allowed. Let this matter be listed. Bihur Pisop, 29th April. After lunch.
May it please your lordship, I beg to mention item 52, lordship. We have
Yes.
taken the consent of other side.
Okay. What Miss, what is the name?
Sharma,
S. Sharma, learned counsel for the
petitioner. Petitioner, your lordship.
petitioner,
Yes, your lordship.
learned counsel for the appellant who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. She submits that she has informed learned counsel for the respondent regarding her prayer for adjournment, who does not have any objection to the same. The prayer is accordingly allowed. Let this matter be listed. 9th of June.
Obliged.
Item 59.
Lucy, I'm extremely sorry that I am not at that time when I made that call received. Lucy, when the eyes.
Yes, Mr. Locker. Any objection? We allow him to for 3. How much time you are seeking?
3 to 5 Lucy, if possible. 3 days to 5 Lucy.
3 days to 5 days. Is it 3 day or 5 day?
5 days Lucy.
I think 3 days will be sufficient because.
3 days.
On the day of
Okay.
Sadhya to.
Heard Miss, what is your name?
Malako Lucy.
Malako, learned counsel for the applicant. This interlocutory application has been filed by the petitioner, namely Sohin Basumatari, in connection with the bail application number 766/2025, filed by the present petitioner. Stop. In this interlocutory application, the applicant has prayed for allowing the petitioner to be released on interim bail for only 3 days to enable him to attend the Shraddha ceremony of his deceased mother, which is scheduled to be held on 29th of March 2025. In support of the contention regarding death of the mother of the petitioner on 15/3/2026, the petitioner has annexed the certificate issued by Government Gambura of the Lailangpara Sarba Herwa Gerwa Gaon. Stop. Though the petitioner has been detained in connection with an offense under Section 20B2C of the NDPS Act 1985 in connection with Nunmati PS case number 64/2025. However, considering the grounds stated by the petitioner in the instant application, the petitioner is allowed to go on interim bail for 3 days. How much contraband was there?
30.85 kg. Ganja.
Ganja. Contraband. क्या लिखा? Three days, that is till on Tuesday you surrender. Till 31/3/2025 on furnishing a bond of rupees 50,000 with one surety of like amount to the satisfaction of learned Additional Session Judge number 1 Kamrup Metro at Gauhati. Subject to following conditions. Two conditions, and third condition is that he shall surrender before the Court of Learned Additional Session Judge number 1 Kamrup Metro on
Lordship, tomorrow is holiday, Lordship.
on 1st of April.
Wednesday.
On 1st of April. You will get the certificate, we'll upload it today itself. या तो विषय काम जाके अपलोड करके किसी अलग को भेज देना. We'll upload it now itself.
Yes, Lordship.
Shall surrender before the Court of Learned Additional Session Judge Kamrup Metro, who shall remand him to judicial custody thereafter. This interlocutory application is accordingly disposed of.
Lordship.
First come.
Item 19.
Wait, Mr. Lordship. Lordship, I beg Lordship accommodation for the day, Lordship. In this case, Lordship, last occasion, there is a direction to substitute, file and substitute petition. But Lordship, regarding respondent number 18, Lordship, we could not find the proper address of the legal heir of the respondent number 18, Lordship.
Take time.
Yes, Lordship.
Heard. Mr. B. Chaudhary. What is this?
Lord, there are different IAs, my lord. File for
Different-
substitution prior, Lord, the appeal has not been admitted. There's a condemnation application. While the
Condemnation.
condemnation application being pending, it came to light that there are few defendants who had, they died before even institution of the suit. So they filed substitution application, but no limitation application was filed. So last
have-
date, they
Will file necessary application, Lordship.
there are four IAs, my lord.
In which case order was passed?
In I 16, Lordship, probably 2023.
I-16. I-16 is for what?
Substitution, my lord,
Substitution, Lordship.
of one.
Ramesh Kalita, Lordship. Is the respondent number 10, Lordship.
I-16 order लिखना. Heard Mr. B. Chaudhary, learned counsel for the applicant / appellant. Also heard Mr. A. Bhatra, learned counsel for
Respondent number 9 and 9.
respondent number 9 and 9A.
A.
Who else is there?
I'm for 14 to 17.
Sorry, Mr.
Appeared for.
What is your name?
M. Bora for R.
Also heard Mr. M. Boro appearing for respondent number 14 to 17.
14 and 17.
Learned counsel for the applicant seeks some more time for filing application for substituting the legal heirs of deceased respondents.
Number 18, Lordship.
Number 18. The prayer is allowed. Let this matter be listed after verification.
After verification.
May.
But the
When-
date may not be fixed.
Because in the meantime, Lordship, we have to
He does not get the
proper
names
address of the
again.
legal heir because Lordship,
Oh,
they are.
then they will never find the.
Otherwise,
It may be reflected as
The-
2 weeks. my lord.
Can it be on 6 weeks, Lordship?
15th of May.
Obviously.
Item 20.
Let's see, there is a office note on 17/3/2025, let's see. Although we have received the notices, but it was, we could, due to some communication gap, we could not publish it in the newspaper. So I want 2 weeks time
Or,
for publication
okay.
in the newspaper.
Heard Mr. U. Datta, learned counsel for the appellant. Also heard Mr. S.P. Sharma appearing for respondent number
2 Lordship.
2. Learned counsel for the appellant seeks some more time for taking steps for issuance of notice by way of substituted mode of publication of the same in newspaper in respect of respondent number 1. The prayer is allowed. Let this matter be listed on 22nd of May.
22nd of May.
22nd of May. The date to be shown in the notice published in paper for appearance of the respondent as 22nd of May.
Public.
Item 21 and 22.
Lordship, on the last occasion, government were to.
Yes, Lordship. I have received the record.
What record?
Regarding lordship, service of notice lordship. The original notice lordship,
Your
Yes.
book.
service book.
Yeah.
Yes. Seal is there.
Yes, what you have to say.
Check whether seal is there.
You go through it. Make your submissions. We'll fix another date.
To fix it.
Let the record be there. Let him go through. Or you want to make submission today itself.
Okay. Maybe allowed to see the records.
Otherwise, we may dispose it of today itself. You are agreed with the quantum?
Yes, lordship. There is, in fact, here also there is no seal. In the other two, first two, there are seals. Here there is no seal. Lordship may produce it.
There is a note of the Zarikara.
On the reverse page of that lordship,
Yes,
notice
okay.
there about service of notice.
There is no seal in fact.
Seal is not there, but signature is there and the
Signature we cannot say.
Jarikara reports is also there.
What is your submission?
So there is no seal. In the first two, if Lordship may peruse the original. Because generally IOC, if someone receives something, there has to be a seal also. And this document has been brought by the private respondent.
You make your submissions.
What has happened also? In the year 1996, land measuring about 63 acres were acquired by the government for us. We are the requiring department also. Thereafter, the respondent has filed an application under section 18 of alia. Reference was there, Lordship. In the reference, the compensation amount was enhanced from 16,000 per katha to 70,000 per katha. However, in the reference, we were not made party. We were not aware. Subsequently, what has happened, while they filed an execution application in the year 2020, Lordship, the deputy commissioner wrote a letter to us on 1/4/2022, requesting us to deposit the decretal amount.
Yes.
Subsequently, on protest, we have deposited it, although we have deposited the amount.
The amount has been disbursed to the claimant.
Yes, Lordship.
I think
You have received.
Take the amount.
And IOC also has deposited the amount in the DCO.
Okay.
we deposited on protest, we have deposited it. But the thing is that, let's say we were not aware. We were neither made a party
Then when you have deposited,
We deposited after the letter in the execution case when they have filed, when DC had issued a letter. On protest, we have deposited.
2022, when this LA appeal has been filed.
appeal was of the year 2002.
No,
no,
in the instant.
This LA appeal. This appeal, thereafter we have applied for certified copy lawsuit. Certified copy, what has happened, we had applied before the executing court. Executing court told us that they do not have the original copies record.
When have you applied?
We applied on. Lordship will come to.
Where is the reason for delay?
Yes. Lordship will come to. Paragraph 10. On July 22, we have applied for the certificate copy. We applied before the executing court. But the executing court told us that original record is not with them. Thereafter, we applied before the concerned court, ADJ 3. In the second week of December 22. On 9/12/22, we applied for fresh certified copy. There also till date we have not received the certified copy of it. In fact, this appeal has been filed without receipt of certified copy. We have also filed a complaint before the district judge, but we didn't receive the certified copy.
Where is the material to show that?
Yes.
On which date you have filed the application for certified copy?
Lordship, kindly come to page 26.
2009.
This is the complaint we have filed.
In Annexure A, also page 14.
Annexure?
A, page 14.
They obtained in 2009
Applied
itself.
2009, they have.
No, this is from the execution record.
Yes.
This is from the execution record, not from the.
Yeah, fine.
In fact, I have filed this.
No, where is the counterfolio of your application that you have filed the certified copy, application for certified copy?
Normally they don't give counterfolio.
Then
We
how
have
this,
got a picture.
how this court will know on what date,
Yes,
apart from
photocopy-
your statement?
Yes, photocopy of the application is available with us. We can produce that.
Apart from the fact that in the complaint to district judge,
Yes,
you have mentioned
yes. I have mentioned it 9/12/22. And along with that application, photocopy of the application was also furnished. But here it is not there. As a photocopy, yeah. Ultimacy last part enclosure. photocopy of the application.
Okay. Thereafter,
Thereafter, we have filed this appeal. Because
without copy of,
without copy, we have filed an IA for dispensing with the requirement of the certificate copy. That was allowed.
yes,
Appeal is filed in the 2024.
Yes. Yes, definitely.
Even after they have knowledge in 2022.
no. Their submission is that they have not received
Copy of
copy of the certificate.
But without copy, they have filed in the year 2024. They have filed their appeal. With copy.
Whether appeal should, the copy of decree should be annexed with the appeal.
Yes,
Yes.
without degree lordship, the appeal cannot be filed. And in the lordship certified copy of this order in 2009, delivery of the judgment.
This is from the execution case.
But it was not mentioned
Yes.
in the petition that it is from the execution case, they have collected it in the.
No, you file this application for certificate copy on 9/12/2022.
Yes, initially we filed it on July 22. July 22 was before the executing court.
And when you came to know about the judgment,
Judgment we came to know about on April 22. Lordship.
and what this Yon book says,
Peon book, Lordship. This is not a peon book, I don't think this is a peon, this is a piece of paper, Lordship. Generally, peon book.
This is service book, lordship.
This is a piece of
That's
paper.
Who's
And
that?
area manager, IOC, Assam Oil Division, Marketing Division, BK Kakoti Road, Ulubaga. Here there is no seal. Nothing is there. Who is the person who has received it? It is also not discernible from this paper. And how the private respondent are privy to this document, I don't know. They have not mentioned anything in this, in their objection. In fact, the paragraph has been said to be from records, matter of records. I don't know from where they got it.
yes,
Yes, sir.
you have anything to say?
Lordship, in our affidavit, Lordship, we have mentioned in page 38, 7, Lordship, that Peon book itself says they accrue knowledge about pendency of the reference case, Lordship, in 2010 itself. And the letter was sent to the petitioner, Lordship, which is in page number 30. Lordship, kindly come to page number 36, Lordship.
Yes,
In copy forwarded to the area manager IOC, Assam Oil Division, Marketing Division. It is given, Lordship, and the same, this is received had this peon book, Lordship. So long from 2010 itself, they are sleeping over their right, Lordship.
averment made that they have accrued knowledge in 2022 is not correct.
Okay, anything else?
It is not believable also because I go see the person concerned, even an officer, if he received this, he has nothing to do personally. It is an PSU. And we were not made party in that case. There is neither any seal and signature, whose signature it is not discernible. What will that officer gain by not providing to us the copy if he had received it?
Heard Mr. M. Gogoi, learned counsel for the applicant. Also heard Ms. D. Burman, learned senior government and learned additional senior government counsel, appearing for respondent number 2, as well as Mr. N. Kolita, appearing for respondent number 1. This application under Section 5 of the Limitation Act 1963 has been preferred by the applicant, Messrs. Indian Oil Corporation Limited, within bracket Assam Oil Division, praying for condoning the delay of 4,792 days in preferring the connected land acquisition appeal, whereby which judgment you are impugning?
Judgment dated 30/10/2008, passed by Additional District Judge FTC 3 in misreference case number 10/2002.
What happened in that is a review application.
No,
Review application has been disposed
not
of,
review,
Lordship.
Lordship.
It is rejected.
It is typographical error here.
It cannot be review application.
It cannot be, it's an appeal.
By impugning the judgment dated 30/10/2008, passed by the Court of London, Additional District Judge FTC, number 3, Kamrup Metro, in misreference case number 10/2002. Stop. Mr. M. Gogoi, learned counsel for the applicant, has submitted that the impugned judgment, the facts relevant for consideration of the instant interlocutory application, in brief, are that in the year 1996, 63.6 bighas of land at Betkuchi, Gauhati was acquired for the present applicant. And the collector had assessed the rate of, assessed the value of land at the rate of rupees 16,000 per katha. The present opposite parties, within bracket private respondent, preferred a an application under section 18 of the Land Acquisition Act 1894 before the Court of London District Judge Kamrup, praying for enhancement of the quantum of compensation as well as valuation of the acquired land. The said reference case was registered as misreference case number 10/2002. Thereafter, by order dated 30/10/2008, passed in this 30/10/2008 within bracket, impugned in this impugned in the connected appeal bracket close. The compensation was enhanced and the rate of acquired land was enhanced at the from 16,000 rupees 16,000 per kata to rupees 70,000 per kata. Learned counsel for the applicant has submitted that though the present applicant was the requiring authority and land was acquired for them only, however, it was not made party in the reference case number 10/2022. And they were unaware about the pendency of the aforesaid reference case. And the applicant was unaware about the pendency of the aforesaid reference case. Stop. Learned counsel for the applicant further submits that it was only on receipt of letter dated 1/4/2022 from the Deputy Commissioner Kamrup Metro addressed to the applicant, whereby it was informed regarding pendency of money execution case number 70/2020 in respect of the impugned judgment and award. And when a request was made to the applicant for depositing the decretal amount of rupees 58,34,131.80 to facilitate the payment of compensation to the claimants / opposite parties. Learned counsel for the applicant has further submitted that after coming to know about the impugned judgment, the applicant preferred 2 review petitions before the Court of London. Which court?
This is against another reference case.
2 review petitions in connected reference cases. And what happened to those review petitions?
In page number 40, Lordship, I have an extra.
Review has been dismissed.
However, both the review petitions have been dismissed. Learned counsel for the applicant submits that as the petitioner came to know about the impugned judgment and award dated 30/10/2008 only in the month of April 2022, the petitioner in the month of July applied for certified copy of the judgment, impugned judgment in the office of the Court of London, Additional District Judge, Kamrup Metro. Stop. Which was the reference court?
Actually, reference code was number three.
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 And executing court was?
Executing code was ADJ two.
Okay.
So we applied there.
Learned counsel for the petition applicant further submitted that the certified copy was initially, the application for certified copy was initially made before the Court of London, Additional District Judge number 2, Kamrup Metro, as the execution proceeding. Execution proceeding. What is it? Namely, money execution case number 7/2020 was pending before the Court of London, Additional District Judge number 2. However, it was informed to the counsel of the applicant by the office of the Court of London, Additional District Judge number 2, that since the case was disposed of about 14 years back in the year 2008, it will take some time for tracing the records. Learned counsel for the applicant further submits that in the second week of December 2022, the applicant was informed that the original judgment dated 30/10/2008 was not available in the executing court. And hence, the certified copy could not be furnished to him. Same was communicated to the applicant by letter dated 27/2/2023.
No, that's it. Thereafter, we applied before the ADJ 3.
When you applied?
We applied on 9/12.
Where is the statement?
13, paragraph 13.
No, in last line continue. Prohibition.
Was informed that the original judgment dated 30/10/2008 was not available to the executing court, and hence the certificate copy could not be furnished to.
Thereafter, on 9/12/2022, the applicant applied a fresh certified copy in the Court of London, Additional District Judge number 3, Kamrup Metro, which passed the impugn order in the year 2008. Learned counsel for the applicant submits that on several occasions thereafter, learned counsel for the applicant visited the office of Additional District Judge. However, the certified copy of the impugned judgment and award was not furnished to it, as original record could not be traced out. Ultimately, the applicant, on 27/2/2023, filed a complaint before the District and Session Judge Kamrup Metro regarding non-furnishing of certified copy of the impugned judgment to the applicant, in spite of applying for this duly, in spite of filing application for the same. He further submits that in spite of filing complaint before the District and Session Judge Kamrup Metro, nothing was done and certified copy was not furnished to the applicant. Ultimately, the applicant filed the connected appeal without furnishing certified copy of the impugned judgment and decree by taking a leave of the court or dispensing with the certified copy of impugned judgment and decree. And as such, a delay of 4,792 days have occurred in preferring the connected appeal. He further submits that the applicant was not negligent in approaching this court by filing the connected appeal beyond the period of limitation. And main reason for delayed filing of the connected appeal is non-furnishing of the certified copy of the impugned judgment to the applicant. He further submits that since the applicant were not a party in the reference case, and since they came to know about the impugned judgment and award only when they received the notice of the execution case, there is no negligence or laches on the part of the applicant in preferring the connected appeal. He submits that the appellant has sufficiently explained the delay, and as such, the delay of 4,792 days in preferring the connected appeal may be dispensed with. Learned counsel for the petition applicant has, however, submitted that in the meanwhile, the applicant, that is Oil India Corporation, Indian Oil Corporation, Assam Oil Division, has already deposited the decretal amount before the before the collector in pursuant to the impugned judgment and award. On the other hand, learned additional senior government counsel, Ms. D.D. Burman, has submitted that you are also opposing. Government is opposing.
In fact,
That-
they have not filed any affidavit, Lordship. No objection at all.
Oral
Original record, Lordship.
has failed to explain, properly explain the delay. She has also produced the original service book of the notice, original service book maintained by the office of the, which office? Deputy Commissioner's office, in pursuant to the direction of this court issued on 10/3/2026. She submits that the delay in filing the connected appeal is an inordinate delay of more than 4,700 days. Hence, same may not be condoned. On the other hand, learned counsel for respondent number 1/claimant has submitted that the appellant was intimated about the impugned judgment by the impugned judgment by the Additional Deputy Commissioner, Kamrup Metro, by its letter dated 7/10/2010. He submits that said letter was addressed to the government pleader, Kamrup Gauhati, by the Additional Deputy Commissioner, seeking opinion regarding the impugned judgment passed in LA case number 9/93, wherein it has been clearly stated that the judgment was passed on 30/10/2008. The opinion was sought for from the government pleader as to whether the case is a fit case for filing or preferring appeal against the impugned order or not. He further submits that a copy of the said letter was also sent to the area manager of IOC, within bracket Assam Oil Division, for favor of information and for necessary action, along with a photocopy of judgment. He further submits that said letter was served on the area manager, IOC Assam, on 8/10/2010. He further submits that the original copy of the service book produced by learned additional senior government advocate in pursuant to this court's order clearly shows that the said letter and the aforesaid letter was served on the area manager IOC on 10/8/2010, and therefore he submits that the applicant were aware about the judgment, impugned judgment in the year 2010 itself. However, from 2010 to 2022, it did not take any step for preferring appeal. In response to the contention raised by the learned counsel for the respondent, learned counsel for the applicant submits that the document produced by the learned senior government advocate today in the court is only a piece of paper without having any seal of the office of the applicant acknowledging the receipt of the aforesaid letter. Hence, same may not be relied upon. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available. This we can keep in the record. Material available on the material available in the record. Tuesday will deliver the order.
Both cases are same. 22 is the similar. 22 same.
Other in both cases stand is same
Same. Everything is same, Lordship.
and the notice
Everything is same, Lordship. Same, this.
Because in
not
the
at all in the
letter Lordship sent to the government leader, many cases are mentioned Lordship.
Only
One,
the reference case is different.
reference case is different.
Yes. Other one is 22 is 205/2001.
yes,
No, Thursday.
common judgment was passed
Thursday.
by the referee.
But common order hobo. Dutate, we will modify the order. Naam likhibo. Let this matter be fixed for delivery of orders on Thursday ki hoy. On 2nd of April.
All right.
23.
May I please, Your Lordship?
Yes.
Lordship, today that the case fixed for IA 23 to 59, Your Lordship, but as per the Knowledge Council for the appeal and the yes,
It can be finally heard, Lordship, because unnecessary
It is I.
IA
for
for
withdrawal, and we have filed our objection that they have not made the owner and driver party. And in our appeal, Lordship,
You are ready for final hearing of the appeal.
yes, we are ready. Only respondent 2 and 3, Lordship. Lordship can take them as deemed served, Lordship, because we had taken by registered AD. That AD has not
Appeal
been
file some.
appeal 127 of 2024.
in the trial court, the driver owner had a heart expert also.
No ex parte.
Yes, Your Lordship.
The appeal is for enhancement,
No, no.
or
no.
dismissal,
No, we have filed the appeal
for
for that liabilities of the owner. That will be as per Ningam and Nanjappan, Lordship.
but owner has not appeared.
Uh,
Owner appearance is necessary.
that's why, Lordship, Lordship, they don't appear.
No, but whether
We can take fresh steps.
notice is served or not.
Notice, but Lordship, AD has not come. Lordship will peruse office note dated 9/4/25.
No, you have to take fresh steps.
Okay, Lordship.
Heard.
Then Lordship will call for the report and then hearing, Lordship. A date may be fixed.
Lordship, may I submit one thing? If Land Council take fair step, then required will be more time because matter pending since
No,
2018.
we
Your
will
Lordship.
issue speed post only.
Short recommendation
Yes. Heard Miss
and last chance.
R.D. Majumdar, Learned Counsel for the appellant. Also heard Mr. S.I. Akan, Learned Counsel for respondent number 1. It appears from office note dated 9/4/20.
25.
25.
It appears that the
Plus
note,
cases listed after 25.
the office note dated 9/4/2025, that notice issued to respondent number 2 and 3 have not yet returned back. Stop. Since the notices were issued way back on 7/4/2025, the appellant is directed to take fresh steps for issuance of notice upon respondent number 2 and 3 by speed post within 7 days from the date of this order, returnable on 29th April, list accordingly.
So
29. Earlier plus.
IA 24.
May it please your Lordship?
Yes.
Your Lordship, we peruse office note dated 13/3/2026. Respondent number 124 has filed their wakalatama. And as regards respondent number 5 and 6, your Lordship, service is completed. As per office note dated 11/4/2025.
Respondent number 5 and 6. So service is complete.
Yes, your Lordship. Service is
This
complete.
is for delay condonation.
Delay of 19 days in filing the appeal.
You are objecting?
I have no objection.
Heard Ms. P. Bhattakur, Learned Counsel for the applicant. On perusal of the office note, it appears that the notice to all respondents have been complete. This application under Section 5 of the Limitation Act has been preferred by the applicant insurance company for condonation of delay of 19 days in preferring the connected MAC appeal, whereby the applicant has impugned the judgment and award dated 30/7/2024 passed by the Motor Accident Claims Tribunal, Morigao, in MEC case number 50/2018. So the applicant has explained the cause of the delay in preferring the connected appeal in paragraph number
To your lordship.
2 of the instant interlocutory application. Considering the grounds shown therein, the learned counsel for the respondent number 1/claimant has not objected to
1 to 4, Lordship.
1 to 4 has not objected to the prayer for condonation of delay. Stop. Considering the above fact, as well as considering the fact that the delay has been properly explained, this interlocutory application is allowed, and the delay of 19 days in preferring the connected appeal is hereby condoned. The registry is directed to register the connected MAC appeal and list the same for admission after a week on a date to fix by.
Lordship,
This,
my name may be reflected in the appeal.
This interlocutory application is accordingly disposed of. Name of Mr. M. Talukdar may be reflected in the cause list while listing the connected MAC appeal for admission.
Obliged.
Okay.
Item 25.
Lordship,
Records have been received. Yes,
record was called for you.
records have not been received. We'll issue reminder. PCRA. Heard Mr. A. Chaudhary, learned counsel for the appellant. Also heard Mr. T. R. Gogoi, learned counsel for respondent number 1, as well as Mr. B. Hajurika, B. Pathak, appearing for respondent number 2. It appears from the office note dated 24/3/2026 that the trial court records have not yet been received. Issue reminder for the same. Let this matter be listed again on 27th of April.
Item 26.
Yeah, Lordship. In the last order, Lordship. Council, standing council for the agriculture university, they submit that they're gonna file it wakalatnama, but given that they have not filed a wakalatnama. Otherwise, matter has been admitted and record HR has been received, Your Lordship.
No, what is to be done now?
Lordship, can it be, or Lordship maybe pass over timing, may call.
Today itself.
Lordship, like.
Yes. We'll take it up after some time.
Item 27.
In this case, also Lordships, last occasion, the service upon the respondent number 2 already been completed. They have filed a wakalatnama and we have filed an additional affidavit that is also been on record. So.
Who has filed it? How many?
I have filed lordship for respondent number 2. Now, respondent number 2 has been arraigned without any reason lordship because the petition that has been filed by him in the court below, respondent number 2 was never a party.
Since we have made a
So,
party,
It's all right. We are not filing any affidavit for that lordship. If my brother want to hear it, we are ready for the hearing. Lordship.
Oh, the appeal is
already
against
said that-
what, which order?
it is against the order dated passed by the learned court below and annexure 18, annexure 7, 85, page 66, 85 2025.
What order?
Since we have filed an injunction application, temporary injunction.
Injunction was
Rejected,
rejected.
and the learned trial court below has allowed the defendant to letting out the suit property to any other persons, without discussing the core issues regarding we have challenged the vital fact regarding the sale deed, forgery of sale deed, and the incapacity of the executor while executing the sale deed, and the agreement for sale, which has been between the defendant number 1 and 2. Since there is a
We'll fix a hearing date.
lordship.
If
Okay,
the
let-
appearance of parties is complete,
Yes.
whether record would be necessary.
Records will
lordship,
be necessary because
No. Let me, my brother has not apprised the court properly, lordship. What has actually happened? I'll just take 1 minute time, lordship. The title suit that has been filed by them, lordship, is for a partition of a property which is self-acquired by me. They filed an injunction in the earlier title suit, lordship, that was disallowed. Against that, they have filed an FAO which is pending before this honorable court. While this FAO is pending before this honorable court, in the argument stage, they again file another petition, which is in fact barred by res judicata. Because the court bill has already decided their right. So far the injunction is concerned.
Against that FAO is,
That they have come, it's a second FAO, whether it is maintainable.
no.
And then lordship will kindly, just a moment, please. You have said I did not say anything. Lordship may kindly come to the FAO if your lordship is considering. If your lordship goes into, lordship, where is their prayer, lordship? Kindly have a look at page number 24, lordship. Where is their prayer in the FAO? Their FAO itself is not maintainable. Calling record at that belated stage will delay everything. Page number 24, then kindly have a look, lordship. Page number 25 is the certificate. Where is their prayer? What this honorable court is going to consider in this FAO? They don't have a prayer at all. Grounds, then certificate. Where is the prayer? That is the copy that has been supplied to us.
we'll call for the scan copy.
Scan copy. Lordship, your kind.
Heard Mr. H. Burwa, learned counsel for the appellant. Also heard Mr. A. Bhattacharya, learned counsel for both the respondents. It appears that appearance of parties is in this case, in this appeal is complete. However, perusal of the records of Ms. J case number 1066/2024, as well as connected title suit may be necessary for considering the instant appeal. Hence, call for the scanned copy of the aforesaid records from the trial court. The registry shall take steps for requisitioning the aforesaid records. List this matter after receipt of the aforesaid records for hearing
Lord.
on 15th of May. 14th of May.
Lordship.
Develop this, lordship.
F28.
Lord, as per the office note, my lord, the respondent number 1 to 4 have filed their wakalatnama. In respect of respondent number 5, it has returned stating incomplete address. My lord, we seek to take fresh steps on respondent number 9.
Heard Mr. A. Bhatra, learned counsel for the appellant. Also heard Miss, what is her name?
E. Devi, I am appeared for
E.
respondent
Devi,
1 to 4.
appearing for respondent number 1 to 4. On perusal of the office note dated
Lord, 16,
6/11/2025, it appears that the notice issued to respondent number 5 has returned without service with a remark within inverted comma incomplete address. Stop. In view of above, learned counsel for the appellant has prayed for allowing the appellant to take fresh steps on the respondent number 5. The prayer is allowed. The appellant shall take fresh steps by way of speed post as well as by usual mode within 7 days from the date of this order, returnable on 13th of May.
Item 29.
Lordship, item 29, madam, I'm appealing on behalf of Mrs. R. Devi, my lord. She's not in station, my lord. She's in Kolkata for treatment of her brother, my lord. She's having a kidney transplantation.
Why this has come
Well,
in?
it is come for, my lord, additional affidavit was directed to be filed, my lord. Placing the Supreme Court judgment. Not hearing will be required, my lord. I pray for it.
Who filed the additional affidavit?
Respondent.
You have filed already.
Because they are similar case was
They are seeking adjournment today.
that they are seeking adjournment, my lord. My only limited prayer. That is also your lordship observed that there was no stay order till date. So it's
Obviously, my lord, condemnation has not been allowed.
execution proceeding is there before the
You can proceed.
that observation may be passed.
No, observation is not necessary when there is no stay order.
They are telling again and again that case is pending before the High Court.
No, we'll
Fix next week.
grant adjournment. Heard Mr. H. Gupta, learned counsel appearing on behalf of Ms. R. Devi, learned counsel for the applicants, who seeks an adjournment on the ground of some personal difficulty on the part of Ms. R. Devi, learned counsel for the applicants. Also heard Mr. A. C. Sharma, learned counsel for respondent number 1, as well as Mr. T. R. Gogoi, learned government counsel appearing for respondent number 2. Learned counsel for the respondent number 1 has submitted that in pursuant to the order dated 27/2/2026, the respondent number 1 has filed the additional affidavit as was directed by this court. Stop. Considering the submissions made by learned counsel for the applicants, the prayer for adjournment is allowed. Let this matter be listed on 13th of May.
Filing item 26.
Lordship, please.
Have you filed wakalatnama?
No, we will file it. I have received instruction to appear, my lord. By next date, we will
Oh.
file.
Heard Mr. T. Gogoi, learned counsel for the appellant. Also heard Mr. What is the name?
I bought a common.
I. Thakur, who submits that he has been authorized to appear in this case and would be filing wakalatnama. However, he seeks some time for the same. The prayer is allowed. Let this matter be listed again on 29th of April.
Item 38.
Yeah, please, your lordship, there is another two similar matters fixed on 27th of April. Kindly fix the same date of lordship.
What is the matter?
There is a delay of 27 days, lordship.
27 day.
Yes, my lord.
You are opposing?
Yes, your lordship will file objection, your lordship, kindly, as my lord has said that they're similar to.
Heard Miss, what is the name?
P. Sharma.
P. Sharma, learned counsel for the applicant. Also heard Miss
P. Kashyap,
P. Kashyap appearing for respondent number
2, 4, and 5.
2, 4, and 5, as well as Miss M. Burman appearing Learned Government Advocate appearing for respondent number 1 and 6. Learned Counsel for respondent number 2, 4, and 5 has submitted that the respondent intends to file written objection against the prayer of the applicant made in this interlocutory application. Hence this the prayer is allowed. Let this matter be listed when it is fixed.
7th of April, Lordship.
Let this matter be listed on 27th of April.
Item 39.
In this case, the step was taken by speed post on 21st to 26. But the postal track report is not placed in the record.
What is your name?
Abjad Majumdar.
Heard Mr. F.Z. Mazumdar, learned counsel for the applicant. Stop. On perusal of the office note dated 24/3/2026, it appears that the office note, it appears that the notice issued to respondents, how many respondents are there?
Only one lot.
To the sole respondent has not returned back. Stop. The registry is directed to place the postal track consignment report of the notice issued to respondent by speed post before this court on the next date fixed. Let this matter be listed 27th of April.
Lordship, after 3 months, 21st February notice, this speed post notice was issued.
27 April we are fixing.
Lordship.
Item 40.
May it please your Lordship. Lordship, as per office note dated 25/3/26, notice of respondent number 1, 2, and 4 was received by respondent number 3, who is the son of respondent number 1, and brothers of respondent number 2 and 4.
None has appeared.
No one has appeared, Lordship.
Heard Miss M. Sakya, learned counsel for the applicant. It appears from office note dated 25/3/2026 that notice issued to respondent number 1, 2, 3, and 4 have been received by respondent number 3, who happens to be the son of
Respondent number 1.
respondent number 1. Hence, and 2 and 4 are,
Brothers, Lordship, of respondent number 3.
stop, as respondent number 1 is the father of respondent number 3 and 2 and 4 are brothers of respondent number 3. Hence, notice issued to aforesaid respondents within bracket 1, 2, 3, and 4 are held to be duly served. It also appears that the respondent number 5 has filed, the engaged counsel of respondent number 5 has filed wakalatnama in this case. However, notice issued to respondent number 6 has returned without service.
Lordship, will take fresh steps through dusty service upon respondent number 6.
Stop. Learned counsel for the applicant submits that the applicant may be allowed to take fresh steps for service of, for issuance of notice on respondent number 6 by dusty mode. The prayer is allowed. The Applicant shall take steps within 7 days from the date of this order, returnable on 15th of May. Stop. If in the event the applicant is able to serve the notice upon respondent number 6 by dusty mode, he shall submit an affidavit in compliance thereto on the next date fixed, list accordingly.
Yes, Lordship.
Item 41.
May I please? Your-
Yes.
May I please? Your- Here the notice has been served to your lordship.
How many respondents are there?
5.
On all,
Yes, all from the same address, your lordship. And the delay is 9 days, your lordship.
heard Mr. N. Upadhyay, learned counsel for the applicant. On perusal of the office note dated 24/3/2026, it appears that notice issued to all respondents have been
Received by number 1.
received by respondent number 1. Who is number 2?
Number 2 is granddaughter of number 1.
Daughter no. Hence, notice issued to
Because she
respondents.
received all.
Respondents is held to be duly served. This interlocutory application under Section 5 of the Limitation Act 1963 has been filed by the applicant, Srimati Sarala Rabidas, praying for condonation of delay of 9 days in preferring the regular connected appeal, whereby judgment and decree dated 22/8/2025 and 8/9/2025 respectively, passed by the Court of London, Civil Judge Senior Division, Golaghat, in title suit number 3/2023, has been impugned in this. No, has been impugned. Stop. I have gone through the reasons for delay cited by the applicant in paragraph number
3, 4.
3 and 4 of the instant interlocutory application. It has been learned counsel for the applicant has submitted that as the applicant was suffering from fracture of
Fracture, tibia, the
leg and was under treatment for a period of 3 months. She could not pursue the matter of filing appeal. Stop. Filing the connected appeal within the prescribed period of limitation. Considering the grounds stated in the paragraph number 2 and 3 of the instant interlocutory application as the sufficient cause which prevented the applicant in approaching this court in filing the connected appeal within the prescribed period of limitation, the period of 9 days in filing the connected appeal is hereby condoned. The delay of 9 days in filing the connected appeal is hereby condoned, and this interlocutory application is allowed. The registry is directed to register the connected appeal and list the same for admission after a week on a date to be fixed by it.
Lovely.
Item 42.
Lordship, this is the delay condonation petition of 17 days delay. Lordship, matter has come for the first time.
Heard Mr. A.J.
Lordship,
Soikia.
I don't have any objection. Lordship. It could not-
Interim for respondent number one,
Claimants,
caveator, owner, can I serve or not?
for small days.
17 days delay.
Oh. On what ground appeal has been filed?
Once, quantum.
Quantum. So the claimant is
For small days.
heard Mr. A.J. Soikia, learned counsel for the applicant. Also heard Mr. A.R. Agarwala, learned counsel for the caveator / respondent number one claimant. This application has been filed by the applicant insurance company under Section 5 of the Limitation Act, praying for condonation of delay of 17 days in preferring the connected appeal. Stop. I have perused the, no, I perused learned counsel for the claimant, applicant, claimant respondent number one has submitted that considering the short period of delay, he does not have any objection if the aforesaid delay is condoned. Since the connected appeal has been preferred mainly on the question of quantum of the compensation awarded to the claimant, the notice to respondent number two is waived. And considering the reasons stated in the instant interlocutory application for approaching this court belatedly after prescribed period of limitation, and as the claimant has conceded to the prayer for condonation of delay, the period of 57 days,
17 days.
17 days in preferring the connected appeal is hereby condoned, and this interlocutory application is allowed. The registry shall register the connected appeal and list the same for admission after a week on a date to be fixed by it.
My name may kindly be shown.
The name of Mr. A.R. Agarwala may be shown as engaged counsel for the claimant while the connected appeal is listed for admission.
Item 43.
Please, this is a condoned delay petition, first time notice may continue.
Mr. A.R. Agarwal, learned counsel for the applicant. This application under Section 5 of the Limitation Act has been filed by the applicants praying for condonation of delay of 14 days in preferring the connected MAC appeal. Issue notice to the respondents. The applicant shall take steps for issuance of notice to the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 8th of May.
Much obliged.
Item 44.
There is a delay of 14 days in approaching this order.
But Mr. A. Bhattacharya, learned counsel for the applicant, this interlocutory application has been preferred by the applicants praying for, under section 5 of the Limitation Act, praying for condonation of delay of 14 days in preferring the connected MAC appeal. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order. Returnable on 8th of May.
Apply. Item 45.
Please, Your Lordship. This is an IA for condemnation of delay. The delay of 31 days. Your Lordship.
Delay of 31 days, same order. Council S. Sharma,
Lordship,
returnable on.
Lordship, but the respondent number 4 and 5 are minors. They are about 12 and 8 years of age. So a notice may not be issued. to them.
No, you issue notice to all. Somebody else may appear on their behalf.
They're presented by respondent number 1. Your Lordship.
Then issue notice to respondent number 1 only. 1, 2, 3, 1, 2, and 3. Returnable on 11th of May, same order.
Grateful.
46.
Delay of 19 days.
How much delay? 19 days. 19 days delay, same order. Returnable on 11th of May.
Item 47.
My Lord, there is a delay of 156 days.
Heard Mr. P. Bhomik, Tenant Counsel for the applicant. This interlocutory application has been preferred by the applicants, praying for condonation of delay of 156 days in preferring the connected appeal, connected MAC appeal. Stop. Issue notice to the respondents. The appellant shall take steps for issuance of notice by speed post as well as by usual mode within 7 days, returnable on 13th of May.
Item 48.
May I please, Your Lordship? Lordship, here delay petition is there. Delay is 139 days.
Heard Mr. S.C. Das. 130,
39. 139.
139 days. Cause title se dekhna. It is employees appeal under section 82. 2 of Employees Compensation. Employees State Insurance Act. यहाँ से देख लेना. Issue notice within 7 days, returnable on 13th of May.
Item 49.
Days delay.
KK Bhatto, 22 days, returnable 20,
4 days.
4 days, returnable on 13th May.
Item 50.
There's a delay of 24 days in filing appeal, Lordship.
M. Talukdar, 24 days, notice within 7 days, returnable on 13th May.
51.
Yeah, there is delay of 248 days.
How many?
248.
248 days, same,
18.
returnable on 18th May.
Blessed.
Item 55 and 56.
Sheikh Hasile Kodgol. Where is the
Today's fixed for Lordship, order. That's really problem. 55, 56.
the contempt case we are closing?
Yes, Lordship.
I have, for the reasons mentioned in the order, the contempt case is closed. But the connected IO
In CRPC we have 2 weeks time may be allowed to file
Some
affidavit in opposition.
contempt case we have closed. And who is for the,
For
Peti-
CRPIO, my lord,
who is for the petitioner?
petitioner is not present.
Who is representing?
Petitioner, some Bormon was there. Name is shown.
No, though there is violation on your part,
Hello.
you go through the order. I have
My lord,
mentioned in the order,
my lord,
but for the sake of interest of the child,
my lord.
we are not taking any action.
Much obliged, your lordship.
But this CRPIO needs to be disposed of at the earliest.
My lord.
Where the wife stays,
Wife, my lord, she is now in Borpata Road
Borpeta Road.
because she
And
was in Jorhat.
Where is the son?
Recently transfer, she resides in Gauhati. From residence, he used to go to office and come.
Son is with her in Gauhati,
Gauhati.
where husband stay.
Husband is also in Gauhati.
Then today the other side is absent. Otherwise, an effort could have been made by the court by calling both the husband and wife
My lord.
to the court.
That can be done later on, later stage also, my lord. Let us, if necessary, my lord, I will file affidavit in opposition, my lord, in this CRPIO.
Okay. None has appeared for the petitioner on call. Heard Mr. M.A. Rashid, learned counsel, M.A. Sheikh,
M.A. Sheikh.
M.A. Sheikh, learned counsel for the
Sole respondent.
sole respondent, who seeks some time for filing written objection in this case. The prayer is allowed. Let this matter be listed.
My lord, may I pray one thing, my lord? I have filed an CRPIO, my lord, in connection with same matter. So, my lord, this case may be listed along with that CRPIO, my lord. Same thing.
Same order has been impugned.
My lord, not same order impugned, my lord. He is telling, husband telling that monthly, twice I was allowed to meet the site. So that is not sufficient. That is his plea. And my plea is this, my lord, that son is not willing to meet the.
No, but you are impugning the order dated 7/9/2024.
Yes,
Same order.
same order, same order.
And you are seeking different relief,
Different relief, but same order.
same order.
My lord. So it
Then
may be joined together.
learned counsel for the respondent has submitted that the respondent has also preferred an CRPIO
29 of
impugning
2020.
the same order which has been impugned in this instant CRPIO. And said CRPIO has been registered as CRPIO number 29 of
2026.
2026. He prays for listing both the matters together. Registry is directed to tag the records of CRPIO number 29 of 2026 along with this case on the next date fixed. List this matter again on 18th of May.
18th of May. Obliged.
Hearing item 53.
It's been breaking. Manu, I'm taking 2 minutes break, short break. Yes. Given item number. Yes.
In this particular case, Lordship, appeal has been basically filed that the loss of burning capacity has been considered by the tribunal at 70%. And total award, he was an amputation of right leg. And he was-
Amputation of right leg.
And he was a mechanic. Lordship has already decided the same judgment. Lordship has already passed the judgment at the same tax. Only Lordship, my submission in this particular case, we have deposited Lordship my record. The 10 lakhs already deposited as per interim order, and that has been released. I think. 10 lakhs has already been released as per interim order. And total award has been passed 34 lakhs 37,502. 34,000 lakhs 37,052. That is the award passed by member MSCT Kasar. Though already Lordship has settled the matter, that is why Lordship I do not like to keep the matter pending, or I will argue the case regarding the loss of earning capacity. Though Lordship has already decided this matter, that loss of earning capacity did not agree to my submission, and Lordship has considered the disability as a loss of earning capacity. In this particular case, the member of the committee which has assessed the disability at 70%, and that has been considered as loss of earning capacity by the tribunal while assessing loss of earning capacity of the person.
And your submission is it should be less.
Lordship is aware that motor vehicle act specifically stated because motor
In
vehicle
the
act
schedule.
in the schedule last portion it has been stated
Okay.
that schedule should be followed as per Employees Compensation Act. Admittedly, he is a worker, he is a mechanic, motor mechanic, and the schedule should be followed for assessment of loss of earning capacity. Lordship will find injuries earlier motor vehicle act, not new. In the new act, there is not 163A. That is why schedule is not there. In earlier motor vehicle act, this is the accident of 2016. So earlier motor vehicle act will apply.
MBA Coronius. Okay.
I'm reading slowly, I can handle this.
Yes,
for you.
yes.
As per schedule 163A last portion, injuries deemed to result permanent total disablement, permanent partial disablement, and percentage of loss of earning capacity shall be as per schedule 1 of the Workmen Compensation Act 1923. So, because Lordship in Motor Vehicle Act, there is no schedule. Tribunal or the court have to assess the loss of earning capacity, considering the loss of earning capacity assessed. So, permanent disability as well as permanent partial disability according to the schedule of the Employees Compensation Act. Because in the Motor Vehicle Act, there is no schedule. In Motor Vehicle Act, there is no schedule regarding different injuries. Only permanent disability has been defined in section 142 of the earlier act. What are the permanent disability?
Yes.
But in case of permanent partial disability, there is no schedule. That is why it has been provided that schedule of the Employees Compensation Act should be followed. May I hand over the book, Lordship, regarding this?
No.
Lordship want to look?
No, I'll
Lordship
go,
has the book, Lordship. Lordship has the book, Lordship can see the.
I'll go through it. Your submission is that since
Lordship, Lordship, with folded hand, I'm submitting, Lordship, because Lordship has already decided the matter
in a different case,
in earlier case, which I have argued, and Lordship has passed the judgment. Lordship has not agreed. Lordship has used it. Lordship has never agreed to my submission, and Lordship has followed the order passed by the tribunal regarding loss of earning capacity. But my submission will be lost in this particular case. Lordship will find
okay.
Lordship will find page 18. May I take a Lordship to page 18 of the appeal memo?
Yes.
Lordship will find claimant has become permanently disabled to the extent of 70%.
Which line?
Middle portion Lordship will find after 16 lakhs 18,000
Yes.
towards medical expenses. Thereafter,
Yes.
claimant has become permanently disabled to the extent of 70% due to the injuries sustained. Lordship got it.
Yes.
And same 70% has been considered for assessment of. Lordship
No,
will
sir.
find at page 21. Page 21. Same disability has been considered as loss of earning capacity. There is a difference between loss of disability and loss of earning capacity.
Yes.
70% has been considered as loss of income. Page 21. For assessment. Lordship got it.
Yes.
70% has been considered as loss of income. But Honorable Supreme Court and this court has held that disability and loss of earning capacity is totally different. Loss of earning capacity has to be assessed considering the employment of the injured and the avocation.
But it can be more also.
It can be more also, considering the avocation of the person, which Supreme Court has decided,
Yes.
considering the avocation of the person. And
Yes.
if it has been decided that he is not in a position to do any other work after injury sustained by him, not only his employment, which he was working. In one cases was a driver, he has lost his job. This court has that it is 100% loss of earning capacity. In case of driver. But in this particular case, Supreme Court has, thereafter, this court has interpreted that loss of earning capacity considering any avocation. I will place the judgment to that effect. Any avocation. And that is why Lordship, the Employees Compensation Act says, Lordship will find a schedule that different injuries, loss of earning capacity has been defined differently in case of permanent partial disablement. So this is different thing. I will place the judgment. Secondly, Lordship will find when disability and loss of earning capacity is considered above 50%. Above 50%, then this Lordship pain and suffering amenities of life disappear. Lordship has already passed a judgment to that effect, considering the judgment passed by Supreme Court as well as.
That he will get against pain and suffering, but he will not get against
Loss of amenities of life. These are any Lordship.
loss of amenities of life goes.
Lordship.
But against pain and suffering, he will get something.
Lordship. Parminder Singh. Most of the court, Lordship, they interpreted disability as loss of earning capacity. Lordship will find
Yeah.
it has followed the Rajkumar and Ajay Kumar's case at page 7. I have Lordship there.
Yes.
Emphasis has been supplied. Rajkumar's case, it may be noted that last portion, Lordship, emphasis. It may be noted that when compensation is awarded by treating loss of future earning capacity as 100%, even more than 50%, need of award of compensation separately under the head of loss of amenities, loss of expectation of life may disappear.
Yes.
As a result, only a token of nominal amount have to be awarded under the head of loss of amenities or loss of expectation of life. Otherwise, there may be duplication in the award of compensation, be that as may.
Yes.
And Lordship has already, my appeal, Lordship has allowed to this effect, but the disability and percentage of loss of earning capacity has not been considered by your Lordship. That judgment. Recently, Lordship has passed. And Lordship, regarding Lordship, Lordship is aware regarding Bimal Nath case passed by this Honorable Court. Para 24 and 28. Para 24 and 28. Though it is under Employees Compensation Act, principle has been laid down. For the opposite discussion, it is therefore may read also para 24.
Yes.
May I read also?
Yes.
From the opposite discussion, it is therefore clear, while assessing the compensation under section 4(1)(c)(2), what the learned commissioner is required to find us whether the such disablement is a permanent nature or which reduces to the earning capacity of the workman in every employment which he is capable of undertaking not merely a particular employment in which he was engaged at the time of accident. For instance, a driver claim compensation contending that he suffers disablement of permanent nature because of the injury sustained by him, or his hand, leg, what has been seen by the commissioner is whether such disablement reduce his earning capacity as driver or reduce his earning capacity in any other employment which he was capable of undertaking depending on his skill. Burden of proving disability and reduction is earning capacity is obviously on the workman who claims the benefit under the act. If the commissioner find that a workman earning capacity has been reduced in the employment in which he was engaged at the time of accident, but he has been reduced to respect of other employment which he was capable of undertaking at the time of accident, depending on the skill, compensation can be assessed under section 41C of the act. In the event, the compensation has to be assessed under section 41D of the act. Workman, however, by reducing acceptable evidence can establish that because of the injuries, he was unable to capacity has not been reduced in this respect, working which he was informing before the accident, but also in respect of any other employment, depending on the skill and also skill required for other works, which he was capable of undertaking at the time, in which event it would be amount to permanent partial disablement, provided the disablement is of permanent nature. For an example, let's say, may I submit one thing? Our advocate, Deepak, let's say Deepak Das was a MLA, his both leg was amputated. Both leg was amputated below knee. Still he is driving car. Both leg was amputated, not only one leg. He come to the court and he was a MLA from Surpeta constituency. And he is driving. So disability may reduce in some cases, in some may not be 100%. Because now development has done, any avocation, he can open a shop, he can do anything. But he is not in a position that he cannot do anything. So loss of earning capacity, considering the person is capable. If he is not in a position to work, he is not in a position to do any work, then it may be different. There must be evidence to that effect.
And burden is on the
Claimant.
claimant that he is unable to
Do any other work.
do any other work.
Any other work. Recently, let's say many people has, after getting the legs installed by the, let's say, their installation agency, they are capable of do everything.
No, there will be some
difficulties are there, pain and suffering is there. Let's say there is an imperfection, there is suffering in mind that my leg has been amputated. Everything is there. But
in
he may not,
the instant case, the claimant was a mechanic.
he cannot do a mechanical work because of his leg. Lots may think that he cannot work, but his hands are thick.
What he will do with hands?
He can, because mechanic work will be done by his hand. Engine repairing and everything he have to do by his hand. So he cannot make the heavy manual work, but he can still do some more.
Yes. How to assess the percentage?
That is why, let's say, this court has held evidence should be adduced by the claimant. This is not burden of the insurance company. That is guesswork, some guesswork should be done.
No, yes, but suppose no evidence has been adduced.
Court will
Then
decide.
to give the just compensation, court has to do some
Guesswork.
guesswork.
I'm not
Your
against-
submission is,
My submission is not against the claimant because I have to assist the court and I have to give the proper compensation. Always I try to submit the court to assist the court to arrive at a correct assessment.
okay. So you are conceding?
Always lordship. I'm not submitting anything that everything passed by your lordship considering the facts of the case
Yes.
is not correct. It is correct.
So
because lordship has the authority to decide.
In
considering
this
the facts.
case, whether loss of earning capacity should be reduced from 70% or it is okay?
Because there is no appeal from the claimant for enhancement of the award.
Enhancement will now be.
There is no considering that loss of earning capacity is 100% because it is not a permanent disability. Permanent disability means he is totally disabled, but he's not a totally disabled person. His only leg was amputated. His suffering, I know what suffering he has after amputation of his right leg. So lordship will decide regarding the percentage of loss of earning capacity. My submission will be lordship, the page 21.
Yes.
Page 21, lordship will find the assessment, how assessment has been made. Medical expenses 50,000. that as per case and process. Nursing of attendant 16,000 rupees. Nursing food special diet 20,000 rupees. Conveyance 10,000 rupees. Pain and suffering and amenities 5 lakhs. Secondly, Lordship, loss of conjugal life 2 lakhs. Future medical expenses 1 lakh. Loss of income 18 lakhs 14,400. And loss of future prospects 7 lakhs 25,000. So my submission will be, Lordship, the directly pain and suffering 5 lakhs will vanish. Because loss of earning capacity has been considered as 70%. Loss of disability has been considered as loss of earning capacity.
Okay.
Secondly, Lordship will find one thing. I left it to Lordship. The tribunal has considered 13,500 as income per month, considering 450 rupees as daily wage.
So that count is not taken, Lordship.
You can make submission after that.
Otherwise, I will think that this is the only point where you can object. You don't have any other point. You wait for your turn.
Lordship, 13,500 has been considered by the tribunal for assessing income of the injured claimant.
At the rate of?
13,500.
Okay.
Of its own. My submission will be, Lordship,
No, what was the basis?
considered 450 per day.
For
By the claimant as just and reasonable income of this case. So consider 13,500.
no, whether claimants depose that he earns 450.
Now he said 30,000. He claimed 30,000.
Oh, it has been reduced.
My submission will be, it is for your Lordship to decide, Lordship. I always submit that it should be as per, because it is skilled labor notified by the government of Assam. Date of accident 2016. 22/10/2016.
What is that rate? 8,000.
Lordship, I'll give the notification.
Okay.
So sum and substance of my submission is this, Lordship. Secondly, Lordship is aware that tribunal has awarded 7% interest per annum from the date of the filing of the claim petition. And tribunal has already held that amount under the head of future prospect, there will be no interest because it is a future amount will be received in future. So tribunal has did not award any award on 7,25,000, which has been awarded under the head of future prospect.
Okay. Yes, Mr. Ba.
My submission is that, Lordship, there is no informative in the judgment and award passed by the learned tribunal, Lordship. The learned friend submitted that loss of earning capacity should be reduced, Lordship. We file application under the MB Act. The procedure to be followed under the MB Act, not WC Act or EC Act.
Okay.
Lordship,
No, his submission is when the accident happened,
Lordship,
at that time, pre-amended MV Act was in
Lordship,
force.
Uh.
And there was a provision that
Lordship,
Schedule of Workmen Compensation Act is to be followed.
Lordship.
That is his submission.
The concept is very different, completely different, Lordship. In case of WC Act or EC Act, there should be employer-employee relationship. And under the MB Act, the question of employer-employee relationship should not be there. And
No, that is not his submission.
Lordship, he was a motor mechanic. He was not the
No,
employee.
his submission is in a motor accident claims case.
Lordship,
Suppose in case of a partial permanent disability,
Lordship,
court comes to a conclusion that compensation is to be awarded.
Lordship,
Then he submits that in pre-amended Motor Vehicle Act,
Lordship,
there was a provision that to assess the loss of earning capacity,
Lordship.
the schedule of the Motorway Workmen Compensation Act should be followed. It was there in the Motor Vehicle Act itself. Now it is not there. Now it is not there, but his submission is that when the accident happened, the MV Act at that point of time contained that provision. Therefore, that should be followed.
Lordship, that is provision under section 163A, not 166.
Okay.
That is 163A, not 166.
Old MV Act is there. Hey, Putul. Old MV Act. Before 19, library khole didi bhau. When the amendment was
Amendment come in 2019.
before 2019, Jekunu MV Act 2019 or Agor.
Lordship can see these books.
No, I will
Lordship, Lordship-
because your condition of your book is already very bad. So I,
Lordship, it is very used all the
but
time.
you have
Lordship,
retained.
only one thing. If he want to argue these points, I will place a judgment to that effect that claim is filed under section 166 or 163A. Tribunal should follow the schedule of the Employees Compensation Act that has been already established by this honorable court. This court has passed a judgment to that effect. For assessing loss of earning capacity, when there is no schedule in the Employees Compensation Act, then court can employ the case work. But in case of assessment of loss of earning capacity, court will follow the Employees Compensation Act schedule. Already the result of this court. I'll give the copy to the court master.
Okay.
Lordship, procedure to be followed under the MBN.
Lordship, I
Is
have
that-
given this, Lordship, the notification issued in 2016 for assessment of skilled labor. It should be 10,500. C, Lordship, 10,500
Yes, Mr. Talukdar.
for skilled labor. Not semi-skilled, skill.
Okay. Yes, your one submission is that schedule of Employees Compensation Act cannot be followed in a inquiry under Motor Vehicle Act. That is one submission.
And procedure to be followed under the MBA is that the disability has to be assessed by the doctor. And the loss of earning capacity is to be decided by the learned tribunal, considering the entire evidence on record. Lordship,
Yes,
kindly see Rajkumar's case, Lordship.
yes, you are right.
And in case of the EC Act, there is no question of occupation or other things. Any of occupation, schedule is to be followed. But here, occupation is to be seen. He was a motor mechanic. His right leg has been amputated. He cannot do anything right now. Lordship, kindly see Ajay Kumar Rajkumar's case.
Yes, that I remember.
Lordship,
Para,
that is there. Para 19. Loss of extent of disability and loss of earning capacity may differ, but sometimes it may be same.
okay.
Lordship, 19, Roman 2. The percentage of permanent disability with reference to the body of a person cannot be assumed to be the percentage of loss of earning capacity. To put it differently, the percentage of loss of earning capacity is not the same as the percentage of permanent disability, except in a few cases. There are cases where loss of earning capacity and loss of extent of disability would be same.
Yes.
Now, Roman 3. The doctor who treated an injured claimant or who examined him subsequently to assess the extent of permanent disability can give evidence only in regard to the extent of permanent disability. The loss of earning capacity is something that will have to be assessed by the tribunal with reference to the evidence in entirety. So loss of earning capacity has to be decided by the learned tribunal. So procedure is there. Under the MB Act, procedure is completely different. Why we take the assistance of EC Act? We file application under the MB Act. The MB Act should be followed. Procedure to be followed under the MB Act, not EC Act. In this regard, there is judgment of the Honorable Supreme Court Lordship. Two judgments. Now, you can see 2025 legal SC 1045, Muhammad Masood versus New India Assurance Company Limited and another. Lordship, at page 3, paragraph 4, Lordship. You got it, Lordship? The present appeal, in the present appeal, the appellant claimant has raised two contentions. Firstly, that the High Court committed an error in taking the income up with reference to the Workmen's Compensation Act, thereby reducing the figure of income which was considered and applied by the tribunal. In this regard, the appellant relied on the decision of this honorable court in so and so and so and so. Next, Lordship, paragraph 5. The first limb of submission has substance. The appellant has chosen to file a claim petition for compensation in respect of injuries he suffered in the accident. After consent by the party, the tribunal adjudicated the same and assessed the income to be 9,000 per month to calculate the amount of compensation accordingly. The tribunal having determined the compensations on that basis, the High Court misdirected itself in applying the criteria under the provision of the Workmen's Compensation Act 1923 to take the view that income of the appellant claimant was liable to be considered 8,000. The High Court consequently reduced the compensation. Same principle should be applied here also. It is next, Lordship, 5.1. It was not permissible in law for the High Court to apply the parameters under the Workmen's Compensation Act 1923 regarding fixing of income when the compensation was assessed and fixed by the tribunal in a claim petition under section 166 of the MB Act by applying principles under the said Act. Now refer the Honorable Supreme Court's judgment in Mastan and another versus section 167 is there. Married it section?
No.
Lordship, then again.
In Mastan.
Next paragraph. The issue stand answered by this court in Mastan and another supra, which held that once the remedy under the Motor Vehicles Act 1988 was elected to be pursued by the claimant, and the tribunal adjudicated the compensation by applying the criteria under criteria and fixing the income, falling back upon the parameters under the Workmen's Compensation Act was not permissible. The insurers could have raised such a defense seeking to apply the provisions of Workmen's Compensation Act. Both the remedies are different. In the aforesaid view, reasons supplied by the High Court in paragraph 10 and consequence reduction in the compensation could not be permitted to stand. The compensation awarded by the employer on the basis of income 90,000 has to be restored. Lordship, same principle should be applied here also. We have filed claim petition under the MB Act. Procedure to be followed under the MB Act, not under the EC Act.
Okay.
Procedure to be followed is completely different, Lordship. Again, there is another judgment of the Supreme Court, Lordship. I think that is not required. Mustan's case.
Okay, anything else?
Lordship, so far as the other heads are concerned,
Pain and suffering.
pain and suffering, etc., etc. There is 3 judge bench judgment of the Honorable Supreme Court. The learned friend referred to two bench judgment. Then 14, 2 TSC 737 SC. It's also amputation case. Similar case, Lordship. 3 judge bench judgment, Lordship.
Which para?
Lordship, kindly see. It's the incident of 2008 loss, 2004 Lordship. And here, in this case, incident of 2016. Lordship, can you see page 740? I have marked it, Lordship. The appellant admittedly, paragraph 11, Lordship. The appellant admittedly was in the hospital as an inpatient for a long time. He was operated upon for 2 times. Here also 2 times operated upon. He, in this case, you and in your case also. He was in the hospital for a long time, 42 days in the hospital as indoor patient. He was operated upon 2 times, and presently he is able to move with the assistance of an artificial limb, and he still has to take treatment, as is evident from the evidence of the doctor. And considering the fact that loss of limb causes lot of pain to any living being, we are of the considered opinion that the compensation payable to the appellant under the head pain and agony, similar to pain and suffering, Lordship, should be reasonable. The tribunal has awarded 70,000, and we feel it appropriate to enhance another 50,000, and upon such enhancement, the appellant would be entitled to 1,20,000 under the head pain and agony. Therefore, we hold that the High Court erred in reducing the compensation payable to the appellant under the head pain and agony. Here it was a case of 2004, Lordship. 2004, 1,20,000 has been awarded for pain and suffering. In our case, it's a case of 2016. After 12 years, it should be more than double. Then, Lordship, paragraph 12. The compensation to be to the appellant under the head, loss of amenities and loss of marriage prospects. He was the bachelor. That is why loss of marriage prospects was considered. Here, in your case, he was married. So, loss of conjugal life should be considered instead of loss of marriage prospect. The compensation payable to the appellant under the head, loss of amenities, and loss of marriage prospect also requires the enhancement. The tribunal has awarded 2,50,000 under the head loss of amenities. We feel it appropriate to enhance the same by another 1 lakh. Upon such enhancement, the appellant would be entitled to 3,50,000 under the head loss of amenities lab. 2 separate headings. 3 judgment. For pain and suffering, 1,20,000 has been awarded. For loss of amenities of life, $3,50,000 awarded. Our case is of 2016. It was a case of 2004. The tribunal next lordship, the tribunal awarded 50,000 towards loss of marriage prospects. We feel it appropriate to enhance the same by another 50,000, and on such enhancement, the appellant would be entitled to rupees 1 lakh under the head loss of marriage prospect. In our case, he was a married person. So instead of loss of marriage prospect, loss of conjugal life should be considered. And hence, the awarded under the head loss of conjugal life. Next lordship, paragraph 14.
Yes.
The tribunal has awarded 5 lakhs towards future medical expenses, considering the fact that the appellant still requires treatment and has to change his artificial limb as and when required. We are of the considered opinion that the compensation under the said head needs enhancement, and accordingly, we enhance the same by another 50,000. The appellant therefore would be entitled 5,50,000 for future medical treatment, including the artificial limb. In every case, amputation can artificial limb is required, and it has to be changed from time to time.
In your
So
case,
here-
1 lakh was, you have been awarded 1 lakh,
1 lakh, 1 lakh only.
but you have not filed any cross.
No, we have not filed. That is why I'm saying that this is not on the upper side.
Okay.
It is on the lower side. And headings, different headings, loss of amenities, life loss of, for loss of pain and suffering. No, Supreme Court in 3 judgment consider separately cause of loss of conjugal life. So under the head, different heads, no interference is required, lordship, my submission. And another judgment is there, lordship. 2025 legal SC 611. Here also, so for loss of for artificial limb, 10 lakhs has been awarded. I have submitted this one. And next one, Kajal's case, lawsuit 2020 legal SC.
Actually,
Here
in
this
all
case,
cases where there is amputation of limb, the claimant should adduce evidence how much it would cost.
lawsuit,
Otherwise, what I have seen, somebody is awarding 1 lakh, somebody is awarding 2 lakh, somebody is 3 lakhs,
lawsuit,
somebody is claiming 20 lakhs for.
Lawsuit.
So that evidence is lacking.
lawsuit. Fact is that amputation is there.
Yes.
For
No, where amputation is
artificial
there,
leg is required.
artificial leg is required.
Lawsuit.
That I agree.
So the amount awarded under the different heads
Should not be
should
interfered.
not be decreased.
Okay.
It is not on the upper side. So far as income is concerned, lordship, the appellant has not challenged the same. How they submit now about the income? They have not challenged it.
Before the tribunal,
Not here, Lordship.
in the grounds of appeal.
Grounds, no grounds is there. Lordship, can you see the grounds?
Okay, no, I am believing you.
Lordship, no ground has been taken, Lordship. No ground has been taken as regards income, as well as the interest also.
Okay.
And the income considered motor mechanic, 450 per day, is not the upper side, Lordship. Court, the learned tribunal make the assessment that is reasonable.
Okay.
And Lordship, kindly see page 20, Lordship, the brief memo of appeal. From 6th line. Though, Lordship got it?
Yes.
Though it is submitted on behalf of the claimant that claimant has suffered 100% loss of income, but that this tribunal is unable to appreciate such submission since the disability is to the extent of 70% only. Rather, this court applying the prudent mind and considering nature of disability and nature of occupation, and nature of disability should be considered. He is a motor mechanic without leg, amputation of leg, how he work? Considering the nature of disability and nature of occupation of the claimant, opines that loss of functional disability or loss of income is also 70%. Duly considered, Lordship.
Okay.
It may be same, maybe different. Normally, loss of earning capacity and the extent of loss of earning capacity and extent of disability may differ, but sometimes it may be same. So
Okay, that you have already submitted.
Lordship, my submission is that there is no infirmity in the judgment and award passed by the learned tribunal, and the appeal is liable to be dismissed.
One thing, Lordship, I am not against the claimant. Lordship will find in the claim petition what has been stated. In para 5 of the claim petition, Lordship, the claim has been mentioned. In para 22, they have stated total compensation has been claimed 28,96,000. Total compensation has been placed 28,96,000. And he has given the heading under the head under which he is entitled for compensation.
Yes.
He has stated what head under he is entitled for compensation. Total compensation has been claimed 28,96,000 in the claim petition. Original claim petition record is here.
Okay.
Total claim is 28,96,000. Secondly, Lordship, the tribunal has awarded marriage prospect and conjugal life. He is arguing, that is why I am arguing. Otherwise, I do not have hesitation to argue. Marriage prospect and conjugal life. He has admitted before this honorable court making submission, he is already married.
Yes.
Marriage prospect is saying marriage prospect. So he is already
In case
married.
of bachelor, marriage prospect should be considered. In case of married person,
And
loss of
conjugal
conjugal life should be considered.
But in this particular case, tribunal has awarded
2
considering the marriage prospect. Lordship will
Not
find
2 lakhs against loss of
1
conjugal.
lakh has been 2 lakhs has been awarded for loss of conjugal life and marriage prospect.
Not for marriage.
Para
prospect.
19,
life.
page 19. Page 19. The where the assessment has been made. Ultimately, that has been recorded in last assessment part. 2 lakhs towards loss of conjugal life, marriage prospect. Lordship got it. Page 19. Lordship got it.
Yes.
Secondly, Lordship, though I do not, I have shut my mouth when he was arguing, claim has been filed under section 166 of the Motor Vehicle Act. We
Yes,
have taken the ground that when claim has been filed under section 166 of the Motor Vehicle Act, claim has two options. One is fault liability, one is no fault liability. And when claim is filed under section 166, on fault liability, he have to prove the fault of the offending vehicle. And 140, he is entitled for injury and for death, permanent disablement. For death, 50,000, and for injury, permanent partial disablement or permanent disability, 25,000, earlier rate. And for fault liability, he have to prove. Otherwise, he have to file a claim under section 163A. Here, he has not take the option to file a claim under section 163A. He has filed this case under section 166. That point was cross-examine him, whether you have any witness examined by you to prove regarding rash and negligent driving of the offending vehicle. You have not examined the police officer who has registered the case, who has investigated the case. He has not examined. No charge sheet has been proved before the Honorable Court. No charge sheet. Only Form 54 has been exhibited. Lordship, only record my submission, Lordship. I do not, Lordship, harm the claimant. I do not like to harm the claimant, but he is arguing claim has been filed under 166. That is our one ground. Lordship will find our ground. Admittedly, claimant has filed claim petition under section 166 of the Motor Vehicle Act, but claimant has neither examined an eyewitness nor the investigating officer of the PS case number 2 for rash and negligent driving of the offending vehicle. As such, impugned judgment regarding fault liability is not legally sustainable. Here, no charge sheet proved, IO has not been examined, no eyewitness examined. Lordship can see Lordship can record that what has been stated in para 22 of the claim petition regarding claiming compensation. Para 22 of the claim petition. Secondly, Lordship will find during cross-examination said, I have not cited any eyewitness. I have also not submitted any charge sheet except Form 54. Lordship may record that. I have also not submitted any charge sheet in this case except Form 54. I have not examined an eyewitness. I have not examined the police officer, only Form 54. That is my submission, Lordship. Because I do not like to harm the claimant.
Lordship, my submission is that in the claim petition, the amount claim is 28,96,000.
And
That is
awarding-
true. I'm admitting it, but it is not mandatory that should be followed. It may, tribunal, if deem it fit, that more amount should be given. That it is the discretion of the tribunal. In this regard, there are several judgments. If you can, I will submit the same.
It is the discretion of the court. He cannot submit. He admitted facts, he cannot argue. It is a discretion of the court. Court can pass any award
Lordship.
considering the facts of the case. That is established principle.
So tribunal can pass award more than the amount claim. In this case, you can, I'll submit 2 or 3 judgments on all Supreme Court. 3 bench judgment is there.
no, not necessary. Heard Mr. S.K. Goswami.
Lordship, so far as the
You
negligence
want
with-
me to keep it part heard?
I'm reading out only paragraph 9.
Of,
Duly considered.
okay. Paragraph 9 of the impugned judgment,
Lordship.
where the fault has been,
Lordship. That
Consider.
has been elaborately discussed, Lordship. And in this regard, there are judgment on also good. The claim case should be considered on the touchstone of preponderance of probability.
okay.
The strict rule of procedural law or CRPC should not be
Okay,
followed.
okay.
Lordship, there is judgment.
No, judgment is not required.
Lordship,
are
paragraph
arguing-
9, it has
We
been,
are arguing with the High Court, Lordship. We are not arguing with the tribunal.
paragraph 9, it has
Regarding
been
this submission.
elaborately discussed.
Okay, I have recorded your submissions. Heard Mr. S.K. Goswami, learned counsel for the appellant. Also heard Mr. M. Taludar, learned counsel for the respondent / claimant. Hearing concluded, judgment reserved.
Obliged, Lordship. Highly obliged.
Obliged.